Dear guests and valued speakers, the conference will continue with the keynote lecture of Alan McKay with the moderation of Tuğrul Katoğlu. We kindly invite Alan McKay and Tuğrul Katoğlu to take their seats on the stage.
Dear guests, it's working now. Dear colleagues, good afternoon, after all. At this afternoon session, Professor Alan McKay will give his speech. The title in English of the speech is The Many Implications of Neurotechnology for Criminal Practice. Let me introduce to you Professor Alan McKay. He is co-director of Sydney Institute of Criminology and academic fellow at the University of Sydney Law School. He is going to make his speech at, I think, the floor is yours, Professor.
Thanks very much. Thank you. And thanks very much. Might be working, yes. It's working now. Okay, so I'm going to talk about the implications of neurotech for criminal justice, and I think there are many. So I'm just going to very briefly explain what neurotech is. We've heard about some of it this morning, but some other aspects to it and who's investing. And so basically, so neurotech is technologies that interact directly with the brain or nervous system by monitoring or recording or acting to influence it. So sometimes it's in the brain, sometimes it's non-invasive, and so we can think about things like epilepsy devices that monitor the brain for the precursors to an epileptic fit. These are implanted devices and then act to stimulate the brain to, avert the fit. And then we can also think about Parkinson's deep brain stimulation that stops the tremors for people with Parkinson's. More recently, of course, Elon Musk's company Neuralink, they've famously developed a brain-computer interface that enables a person with who's paralyzed from the neck down to control a cursor by thought alone, really, by detecting neuroactivity in the motor cortex and stimulating the brain in order to by detecting activity in the motor cortex in order for the person to control a cursor and thereby play games or control other devices. And then other forms of neurotech decode neural images, so that, putting someone in an fMRI machine and then showing them a movie and then using the neural activity decoded to do a hazy reconstruction of the brain, of the activity in the brain and reconstruct the image. And then other forms of neurotech that are not available in humans, they decode the, so this is some work done by Raphael Just and others, and what the device does is it monitors the brain of a a rat as, I see, a visual stimulus, something like, say, for example, a food stimulus, and then the rat licks because it's seen a food stimulus, and then they replay that, triggering the brain, playing the brain, so that's stimulating the brain, and the rat behaves as if it's seen a food stimulus, but no food stimulus is present. They've just induced a hallucination in the rat. So there's a variety of other applications, not just therapy. So, you know, computer gaming, I don't think there's a great application for it, but some people are playing games using neurotech. I learned on this trip, actually, that the Turkish artist Refik Anadol is using neurotech, EEG, non-invasive devices in his art. Perhaps one day it might be turn out that it's a good way of getting into the metaverse, but not yet. And then at the moment we've got military institutions that are interested in neurotech. So cognitively enhanced super soldiers are something for the future. The idea of being able to increase the attention you know, of a soldier, maybe be able to make them stay awake for long periods of time. This would, of course, be an advantage in the battlefield, and it's something that is being worked on. Some universities have got brain drone races now in America, so students use an EEG headset and control a drone, and the idea is that this will you know, confer a military advantage. And then monitoring workers' attention, that's something that happens in my country. So, for example, somebody's working in a heavy goods driving a heavy goods vehicle in a mine. The device would monitor the brain, and then it alerts them if attention starts to slip, or they start to become fatigued in order to avert a workplace accident. And then, of course, we've got criminal justice, which is the topic for me today. So there's a company an American company called Brainwave Science, and what they do is they've got an EEG headset. So that's an external headset that the police will put on you while you're being interrogated. And the idea is that it will detect what's known as guilty knowledge. So to explain what guilty knowledge is, so nobody in this room has seen the interior of my flat. I have. And so the idea is that my neural response to an image of my flat would be different from yours, because you haven't seen it, whereas I'm recognizing it. And so, of course, that is something that would be of interest to the police in an interrogation, or the security services. So they would show something like a bomb or the crime scene with this neural device on, and then get some information about whether the person has seen it before. And so this is Tan Lee from Emotive, and she's got a headset. That's a kind of more workplace brain monitoring one, you know, for wellness. And the person here has got the interrogation device that is used by police in Dubai and Singapore, I understand. I think I've also heard in Japan. So there's a lot of investment in neurotech. The reason I just put this in, not particularly in the criminal justice side, but there's just a general interest in it. And the consequence of that is, I think, that it becomes likely that for therapeutic reasons or for other reasons, there's likely to be more neural devices become available in the future. Moving to criminal justice, so there's no cases of neurotechnologically mediated crime yet. nobody's been convicted of an offence that they committed by way of brain-computer interface, for example, but there is a history of using neurotech in the criminal justice. So one of the things I've worked on for quite a while is an area, a scholarly discipline, which is sometimes known as neurolaw, and it's looking at the question of what would a hospital brain scan mean for a court. So let's say there's an offender who's been sentenced for an assault, say, and they've got a forensic psychiatrist, and the forensic psychiatrist refers to a brain scan, and the brain scan is kind of neurotech hospital grade, from an MRI machine or something like that, and it looks like the defendant, the offender, has got a bit of dementia. So there's been a lot of discussions about what should the courts make that's evidence that's come from brain scans. And I've written about that in a case called R Against the Poor and others. And then, of course, the newer form of neurotech in criminal justice is this brain monitoring during interrogation to see if somebody's got guilty knowledge. But let's say, what if neurotech becomes more widely used in, just in society, really? So one thing is people are probably going to increasingly start acting in the world by way of brain-computer interface. So at the moment, there's a very small number of people that have got implanted computer interfaces. They're all in clinical trials. You can get some control with the EEG headset and control things. But let's say somebody commits an offense by way of brain-computer interface. So we heard from Ashley earlier, we talked about the mens rea, so that's one of the elements for crime. But another element is the actus reus. So that's the criminal act. So the prosecution in a serious matter, they've generally got to prove both that the person has performed the actus reus and that they had the mens rea. So the mens rea might be intention or something like that, intention to kill. Now, there's something unusual about the actus reus in the case of somebody acting by way of brain-computer interface. So let's say somebody commits the revenge porn offense. That's the intimate image abuse offense. So they upload intimate images of another person non-consensually, knowing that the other person doesn't consent, and humiliates them on the internet. So that's an offence in my state. But let's say it's all done by way of brain-computer interface. There's no bodily action. Then there's something odd about the conduct constituting the actus reus. Is the actus reus a mental act? Say the act of imagining a hand wave to control the cursor. Is that the actus reus, or is it a kind of neural activity? So they've kind of jiggled their motor cortex. That sounds weird, So it might be a reconception of the actus reus. And then, of course, that's without the thing going wrong. If the device goes wrong, then you might think, well, is this to be seen as a device that the person was using, or are they a cyborg and it's just kind of part of them, and so they went wrong? So I've recently published a piece on a chapter in a Routledge handbook, the Routledge International Handbook of Criminal Responsibility, and it looks at the defences. So we've got a test that's been very influential of insanity, the mental illness defence, and it came from England. It's called the McNaughton test, and it's influenced a number of other countries, so Australia, for example, and the US. And basically the test is a person has got access to the insanity defence if they didn't know the nature and quality of what they did, or they didn't know it's wrong according to standards of ordinary people, and that results from a defect of reason which results from a disease of the mind. So those words, disease of the mind, are important here. So let's say a neural device, and a typical disease of the mind for the insanity defense would be schizophrenia. So somebody's hallucinating, they don't know, they think they see an animal, but in fact it's a human and they kill them. Then they don't know the nature of what they did. It's a defect of reason because they were hallucinating, and it came from a disease of the mind, that's schizophrenia. But let's say instead of that, it's a neural device that fails. And the neural device, let's say it's a neural device to treat some other condition, and that neural device caused the hallucination. So do they have a disease of the mind? It's not clear. You know, like maybe you could think of it, well, they just had this device that failed. So it's not a disease of the mind. Or you could think of it, well, actually it's just that, you know, like Alan's he's got some dentistry, he's got some fillings in his teeth, a couple of, you know, bits of metal in the elbow when he fell off the bike. He's a cyborg, and they are a neurocyborg. So this cyborg guy's brain-mind system is diseased. So it's not clear. And, you know, it matters because if they've got a disease of the mind, then they've got the insanity defense and they should be sent to a mental hospital until they're well. If they do have a disease of the mind, well, maybe they just have no mens rea and they just made a mistake and they should just go home. So a lot turns of it. But the point here is that there's an issue about the boundary of the defendant. Where does the defendant end? You know, like, does the defendant extend into their neural device, or do they end at the sort of wet, organic part? Now, let's say things move on a bit, and wirelessly they start to have some of the processing of neural devices done in the cloud. It becomes even more complicated. Then do you think, well, does the defendant extend up into the cloud? A bit of the defendant's disease is up in the cloud. So it's a tricky thing. And it raises a broader question, I think one that Ozan has considered, like in the context of human rights. What's a human being? You know, like if there is, does it just end at the organic part, or does it go into the machine part and the cloud part? Evidence. So let's say people start to have neural devices, and they kind of, you know, like people have got them for various reasons. They've got them, you know, because maybe it's in their earpods, or they've got a therapeutic neural device or whatever. And so lots of people have neural devices. So then what might happen is, unusually for the law, there might be real-time neural data at the time of offending. And so that will be something of interest to the criminal justice system. But then you can think, well, is that okay? I mean, you know, are we starting to, what kind of life would it be if you know that your very thoughts and your emotions, as recorded by a neural device, or allowing people to make inferences about them, might be used to convict you in a criminal matter? So you might think, well, you know, is that going to be a chilling effect on thought, and raises the human rights issue of privacy, mental privacy, and also freedom of thought, which is an emerging right that, well, it's in the Universal Declaration, but it's a right that's on the up now. Criminalization. So let's say, you know, like, at the moment, in my country, Hells Angels gangs sometimes make, they manufacture drugs, and some of these drugs cause harmful effects. And now it might be that people start to try and hack their neural device and use them to get high, and maybe in ways that makes them more disinhibited and creates a social problem. So you might think, well, there might need to be some new offenses. Think about hacking neural devices, you know, especially wireless ones might be hacked. And so, you know, hacking into a bank seems to have a different quality to hacking into someone's neural device, or even hacking into their neural device in order to impact their behavior. So they might need to create some new hacking offenses. Sentencing. So the epilepsy device that I mentioned at the beginning, that considered, it's inspired from the FDA epilepsy devices that are created by a company called Neuropace, in fact, that monitor the brain 24/7 for a person whose epilepsy is not responding to the medication, just sort of echoing like fourth-line treatment, I suppose, for the medication, and then it stimulates the brain when it notices the precursors to a fit. So some philosophers, Frederick Gilbert and Susan Dodds, they envisage that in the context of an angry outburst. So let's say somebody's got intermittent anger, I think it's called intermittent explosive disorder. They've got this kind of predisposition to get really angry. So that will presumably have some neural precursors that's angry. And it seems like in principle a device could look for the neural precursors to the angry outburst, and then instead of stimulating to stop a fit, stimulate to calm them down. And then, you know, so taking that, I've sort of got, being a lawyer, I've sort of looked into it, and I think that it would be permissible for a judge in my state, New South Wales of Australia, I'm not sure about here, but I'd be interested to hear anyone's thoughts, to make an order saying that somebody must keep this device going for the duration of the sentence. So let's say I'm a lawyer and my client's on the edge of going to jail. They've got a sort of mental condition that has led to their angry outburst and assaulting someone. They might go to jail or they might not. They're not going to use the insanity defense because they don't want indefinite detention, and maybe they don't meet the criteria anyhow. And so at sentencing, they just say, well, don't send, or they ask me to say, well, don't send me to jail. You know, Professor so-and-so has said that this neural device will manage the, you know, the anger problem that they've had, and just make it a condition that they stay in the community and keep this device active for the next 2 years. I think a judge can make that order. So I've kind of done that. And this is how it would go in under Australian law. I think there's a legal basis for a judge making that order, nothing really to stop them. But one way of thinking about this is, in some ways, it's a bit of a shocking thing, because we heard about Clockwork Orange earlier, and really it's just the judge is making an order saying that a person with a disability, so they had a mental condition in my hypothetical, is to be subject to 24/7 neural monitoring all the time, and they're going to get this kind of mental health intervention that a black box AI system decides when treatment is needed. So, you know, there might be some things that, you know, that are to be said for it. I mean, it could, like, prison is a nasty place, and it costs money. It might cost you know, cut the cost of imprisonment. Some offenders might prefer this because prison's so nasty and they can stay at home. It won't disrupt their work, perhaps. It fits well with some social trends, like there's a kind of social trend in a lot of countries to managing risk, and a kind of general surveillance culture, and the idea that technology can solve social problems. It fits with some trends. But, you know, it might be that, you know, so first of all, it might be kind of introduced by the defense. So in my hypothetical, I said, don't send my client to jail, just make the order that they keep this neural device active for the next 2 years. But then it might start to spread. So I don't know if people have heard of a device called the interlock. So the interlock is a device that, if you've been drink driving in Australia you can get this device, and it goes in your car, and you have to blow into the, into the device to detect try and detect the blood alcohol level, and it won't start if you've had too much to drink. And so some people have said, early on, many years ago, that, okay, well, don't ban this person from driving. Just the person's got the interlock in the car. It's just not an issue. He or she can't drive anyhow. Just leave their license. So it started out that way, but now the interlock is just kind of a standard thing. Like if you've been drink driving and you get your license back, you have to submit to getting an interlock. So it went from a defense thing to just a kind of standard thing. And so it could be the case that this, this kind of neural approach starts off in the defense, and then it just becomes a standard thing. And you can almost see the media getting behind it. So like somebody commits a domestic violence offense, which are a big issue in Australia at the moment, and then in the papers it says, why didn't he have a neural device? So you can imagine it expanding. So there's various human rights concerns to all of this. I think the reference earlier to Clockwork Orange is it's a film and a book that's worth thinking about again. So one thing is, you might think, well, this device intervenes on the neural activity of this person who's got a disability and is in a very difficult situation because they got on the edge of going to jail. So in the Universal Declaration and the International Covenant of Civil and Political Rights, there's mental integrity. Maybe it's an infringement of mental integrity. Privacy. The device constantly the hypothetical device constantly takes data. Maybe that's an infringement of a person's mental privacy. And also what happens to the data after, like who's running it? Is it run by Meta? Freedom of thought. That's another right that, as I say, I think is on the upside. But, it's starting to become more significant. And then the other thing about the whole thing is you can think of it as a coercive offer. So it's like I'm making you an offer, wear the neural device or go to jail. So it's kind of somewhat coercive, and there's some sort of ethical issues about that coercion. And then, other issues. What if the device fails when the person's on the bond? What if somebody hacks into it and dials up the impulsivity rather than dials it down? Are they in breach of the condition if they reoffend? So one question to ask is anything new? So C.S. Lewis, back in the 50s, said he was worried that the rehabilitative approach to offending might make an offender undergo all those assaults on a personality which modern psychotherapy knows how to deliver, to be remade in some pattern of normality, so like there's got to be a decision about what's a normal human being hatched in a Viennese laboratory, which I never professed allegiance. So you can just alter it. That was back from the 50s, and they were talking about psychotherapy. We can alter it for today, and it now becomes neurotechnology, and instead of being hatched in a Viennese laboratory, it's in a Silicon Valley startup. So what's new? I mean, I won't go through the whole slide, but one of the things is that, in earlier forms of say, medication approaches to rehabilitation, the data privacy thing was not really there. There was mental integrity, but not so much data privacy. Medication don't have the risk of hacking. That seems to be a new thing. And there isn't an automated decision-making process, black box type thing with the medication. All right, so just moving out so that was the offender, just to move on. Have I still got a wee bit of time? So, the title of the talk is The Many Implications for the Criminal Justice System. There are other people in the system, not just offenders. So what about policing? So there's been a big program to try and engineer super soldiers, which who knows how it's going, but it's something that DARPA and probably agencies in China and so forth are working on. Could that go from kind of super soldiers to super cops? You might think, well, police officers make high-stakes decisions. Some of them have weapons and they use them, and things can go wrong. They shoot the wrong people. Maybe they should have their brain monitored, like the heavy goods drivers in Australian mines. Maybe there's even a stronger case for that. And then, because they are in such high-stakes decision, maybe also they should be cognitively enhanced. If that becomes available, you can make them pay attention more, and not have slips in attention. So maybe they should go the same way as they're trying to make soldiers go in the future. And then you can almost imagine, like with AI. So right now with AI, we had a prosecutor in residence at Sydney Uni a while ago, and he did a talk about AI in the context of criminal justice. And essentially there's an arms race. Like there's the criminals are developing fraud AIs to perpetrate frauds. The cops are trying to have AI that will detect them, and there's this kind of arms race going on. So could that might happen with neurotech? Other people in the legal criminal justice systems are lawyers. So I used to be a lawyer. I didn't do criminal justice. I did commercial work, but we used to bill by the hour. And so basically, like if I'm acting for you, then I charge by the hour, and the amount of time I pay that goes into my fees. But really, you could have a more or less crude form. You could have billable units of attention. So I raised this in a report I did for the Law Society of England and Wales in 2002. So like with the EEG headset, they're now purporting to be able to monitor attention. So why should the client pay for times where their lawyer's not really paying attention? Why not just pay for when they're giving it the file the full attention? And then law is a competitive environment. So if you're a young lawyer, I used to be a young lawyer in a law firm. People are vying for a competition, and like, say my colleague starts cognitively enhancing, if that becomes possible, it will put a pressure on me. So you can imagine that happening. Of course, judges have got high-stakes decision to make. So let's say, why you could even think, well, maybe judges should be monitored. Like if they're hearing evidence and they're kind of not paying attention, maybe that should be a ground for appeal. Or maybe they should be cognitively enhanced with some sort of, transcranial stimulation, maybe if that starts to work to improve their attention levels after lunch. But then you start to think, well, what about these people are workers, and they've got rights, human rights, they've got right to privacy, they've got right to freedom of thought. Maybe this is a kind of interference. The final point is, so the talk is about the criminal justice system, and there's, I've made a point that there's a number of different actors, isn't there? There's police, there's offenders, there's judges, there's lawyers, and everything I've said has been quite sort of individualistic. What about the right to mental privacy? What about the right to freedom of thought? But there's this new system that might ultimately get created, which is a different kind of system where things are a bit more neural and maybe a bit more connected up. And you might think of what kind of emergent properties might might emerge from that system. The thing about social media, right? Social media, okay, from an individualistic perspective, it enables me to connect with my friends and things like that. But then it turned out that social media has got these kind of emergent properties. It's got echo chambers and polarization and stuff. And presumably this system will have some sort of emergent properties. All right, so to conclude, for criminal lawyers, I think there's a variety of challenges, a variety of things to think about. At the moment, the issues are what should be made of hospital brain scans in criminal justice matters, and then more controversially, you know, should the police be allowed to use neural devices, and what should be done with that evidence if they do use that? But neurotech might affect a lot of people in criminal justice in the future, and so some of the issues might be human rights issues, but not just human rights issues. So the actus reus issue is not a human rights issue. It's like the issues go beyond human rights. And then finally, you know, the whole thing, a kind of neurotechnologically enhanced system, maybe with a bit of AI thrown in as well, it's going to create a different kind of system. And, you know, like sociologists study systems, but, you know, people might need to, criminal justice scholars and criminologists might have a look at what comes from this changing kind of socio-technical system that might ultimately be created. So that's my talk. Thanks again for the invitation.
Thank you, Professor Makel. Now we can receive some questions. We have 15 minutes for the questions. Will be translated.
Thank you very much for the talk. So some of the, you mentioned the systems that use AI. And for example, if we are using neurotech for interrogation. Now, some of these technologies are obviously learning technologies, so they, you know, they change during the usage. But also humans are learning, right? So you can, if you have this kind of technology at home, if it's widespread enough, then you can also train yourself to respond to it in a certain way. So it becomes an arms race in that case. So do we need to think about what it might become in the future when we are doing the legislations, for example, about this? It happened, for example, with fingerprints. I mean, people thought initially that the minutia systems that we store in our fingerprint databases were one-way hashes, so they could not be reused to recreate the fingerprint, to place the fingerprint somewhere, until somebody managed to do that. So the technology progressed, and the former assumptions were invalidated. So,
yeah. So I do think I think it does make sense in lawmaking. I mean, so the whole sort of gist of this, it was kind of a largely anticipatory exercise, although not entirely, to try and encourage some thinking about how things might change. And when it is time to make changes, and probably it's, you know, for most things it's not, you know, like maybe it's time to change privacy laws and things like that. There may be some changes that are, we know enough about the way things are going that are ready to do now, but a lot of it is kind of looking to the future. But when things do become a bit clearer, you know, like, I think it does make sense to think about how might others respond to a legal change, and I think that's an important part of lawmaking. And yeah, so I think that was the main gist of the point, was it? Yeah, so I'm on board with it. It seems right to me, yeah.
Thank you. So you talked about many things that, many possible scenarios, futuristic scenarios that some of them are utopic and some of them are maybe dystopic. But I would like to kindly ask you to make a wrap-up and clarify. In any of the possible applications, these neurotechnological applications to law system, you listed like 100, but are there any currently applied of them? Can you wrap up any of those that are currently being used in any part of the world? I don't know.
So the two that are currently used would be brain scans in sentencing. You know, so that's been around for quite a while, and so MRI machine brain scan is a sort of fairly commonplace thing in sentencing in my state, and the new one that's emerged is the police use of EEG headsets to detect guilty knowledge in, and I understand that's the places I believe that to be the case is Dubai, India, and Japan. So they're kind of the current ones.
Apparently, there are no other questions. So then, I thank you again, Professor.
Thanks very much.
Thanks again.
Thanks again for the invitation.
Welcome back. Now to begin the panel on Neurotechnologies and Law, we would like to invite speakers Elif Küzeci, Harry Lambert, and Ozan Erözden to take their seats on stage. We also kindly invite Sibel Çakır to stage to moderate the second panel.
Good afternoon. Welcome to this afternoon session. This session's topic is Neurotechnologies and Law. First speaker is Elif Küzeci. She is from Bilkent University Law School. Neurotechnology, metadata, and personal data protection is her topic. Thank you very much. Please. Nerede isterseniz bekle.
Peki, şimdi çalışıyor galiba. Evet. Arkadaki arkadaşlar da duyuyorlar değil mi? Tamam. Tekrar merhaba. Öncelikle Ozan Hoca'ya beni bu etkinliğe davet ettiği için gönülden teşekkür etmek isterim. Çok aydınlatıcı, ilgi çekici konuşmalar dinledim. Ve farklı bakış açılarıyla bir konuyu değerlendirmenin ne kadar önemli olduğunu bir kez daha düşündüm. Bu nedenle bir kez daha teşekkür ediyorum hem Ozan Hoca'ya hem de bu etkinliğe gerçekleşmesinde emeği olan herkese. Benim başlığım nöroteknoloji, zihinsel veri ve kişisel verilerin korunması. Bir iki ufak hatırlatma ile başlayacağım ama devam etmiyor galiba. Enter'la ya da okula geçemedim ama. Ha. Tamamdır, ben başlayayım. Hallolunca slaytlardan devam ederiz. İnsan zihni pek çok etkinliği gerçekleştiriyor ve aslında bir yönüyle gizemini korumaya devam eden etkinlikler bunlar. Teknolojideki gelişmeler, bilim ve teknolojideki gelişmeler bu sır perdesinin kısmen aralanmasına neden oldu ve olmaya devam ediyor. Öte taraftan zihnin gerçekleştirdiği etkinlikleri düşündüğümüzde hayallerimizi, duygularımızı, düşüncelerimizi, değerlendirmelerimizi, yargılarımızı, hafızayı, bütün bu büyük yapı içerisinde bazı hususlarda büyük ilerlemeler kaydettiğimizi görüyoruz. Benim konuşmam içerisinde özellikle zihnimizdeki verilerin dışarıya aktarılması durumu ve zihinsel verilerin işlenmesi konusu odakta yer alacak. Bunun için başlarken birkaç gelişmeye işaret etmek istiyorum. Buraları geçebiliriz diye düşünüyorum. Bu yıl 2024 yılı ilk insan EEG kaydının 100. yılıymış. Ben de hazırlıklarım, çalışmalarım vesilesiyle öğrendim. Ve geçen 100 yıl içerisinde sadece bir örnek olarak EEG'deki gelişimi aktarmak istiyorum. Benim odak konum açısından elbette. İlk kez insanın beynin elektriksel aktivitesinin kaydedildiği zaman 100 yıl öncesine denk geliyor. Ve geçen zaman içerisinde bu kayıtlar aracılığıyla pek çok bilgiye ulaşılabildiğini, erişilebildiğini, insanların daha iyi bir yaşama sahip olabilmeleri ya da rahatsızlıklarının tedavi edilebilmesi için büyük bir yol kat edildiğini görüyoruz. Öte taraftan bu gelişmeler EEG gibi bazı araçların yalnızca sağlık alanında değil, başka farklı alanlarda da kullanılmasını sağlıyor. Devam edebiliyor muyuz? Örneğin ilk insan EEG kaydının 100. yılı dolayısıyla Nature dergisinde yayınlanan ve 500'den fazla konuya ilişkin uzmanın katıldığı katkılarıyla oluşturulan bir makale içerisinde EEG'nin bugün geldiği nokta yanında önümüzdeki dönemde, önümüzdeki 60 yıl içerisinde bu kayıtların hangi amaçlarla kullanılabileceği değerlendirilmiş. Bunları incelediğimiz zaman aslında yalnızca sağlık amacıyla değil, bugün tüketimle ilişkilendirdiğimiz doğrudan tüketiciye erişecek bazı uygulama alanlarının da olabildiğini görüyoruz. Devam edebilir miyiz acaba? Ben de ettim galiba. Bir örnek olarak aramızda kullananların da olduğunu tahmin ettiğim Apple'ın AirPod'una ilişkin geçen sene 2023 yılında Amerika'da alınan bir patentten söz edebiliriz örneğin. Apple, burada tarihini de görebilirsiniz, 20 Temmuz 2023 itibariyle yaptığı patent başvurusunda AirPod'lara entegre edilmiş sensörler aracılığıyla EEG de dahil olmak üzere çeşitli kayıtların alınmasının mümkün olduğu bir cihazı esasında sundu. Devam edebilir miyiz? Teşekkürler. Bir başka örnek, Kaliforniya merkezli bir şirket, Brainbit, böyle bandana, şimdi Nadal da yakın zamanda tenise veda etti, emekli oldu. Onun bandanasını andıran bir başlık aracılığı ile EEG ölçümü yaptıklarını ve bunun doğrudan tüketicinin kullanımına sunduklarını duyuruyor. Kendi web sitesi üzerinden sipariş de vermenin mümkün olduğunu anlıyoruz. Ve muhtemel kullanım alanlarına ilişkin kendi sitelerinde yer alan örneklere baktığımızda bunların oldukça çarpıcı olduğunu görebiliriz. Bir tanesini sadece değerlendirelim. Online dating, çevrim içi ne olabilir? İşte flörtleşme ya da randevuleşme etkinliklerinde ilginç de bir slogan bulmuşlar. Listen to your heart is not enough diyor. Kalbinin sesini dinlemek yeterli değil. Gerçekten ilgini çektiğini anlamak için beynine başvurmak ister misin? Ona göre kaydırırsın diyor birini tercih edecekken. Ve diğer kullanım alanlarının da esasında doğrudan sağlıkla ilişkili değil, tüketim ya da eğlence sektörü içerisinde değerlendirebileceğimiz alanlarla ilişkili olduğunu görüyoruz. Bütün bu gelişmeler, tekrar belirtmek gerekirse, yalnızca daha sağlıklı olmak ya da mevcut rahatsızlıkların giderilmesi için değil, bunun ötesinde pek çok farklı alanda zihinden ya da beyinden ya da insanın sinir sisteminden elde edilebilecek bazı bilgilerin yakın zamanda günlük yaşamımız içerisinde daha entegre olarak karşımıza çıkacağını gösteriyor. Haliyle bu durum temel hak ve özgürlükler açısından önemli soruları beraberinde getiriyor. Nöral haklara ilişkin son yıllarda artan oranda tartışmanın yapılıyor olması, bu konuda hukuksal düzenlemelere ne oranda ihtiyaç duyduğumuz ya da mevcut düzenlemelerin ne oranda bu alanda koruma sağladığı soruları öne çıkıyor. Elbette ki en çok atıf yapılan gelişmelerden biri 2021 yılında Şili Anayasası'nda yapılan bir değişiklikle anayasaya aslında zihin ya da beyin aktivitesiyle ilişkili olan zihinsel verilerin korunmasının da eklenmiş olması. Nitekim bu hüküm içerisinde beyin etkinliklerinin korunması ve özellikle de bunun içerisinde beyinden kaynaklı bilginin korunmasının yer aldığı açıkça belirtiliyor. Başka bazı gelişmeler de var. Özellikle 2024 yılı açısından dikkat çekici gelişmeler. Amerika'da 2 eyalette sinirsel verilerin ya da nöral verilerin kişisel verilerin korunmasına ilişkin düzenlemelerin içerisine eklendiğini görüyoruz. İlk olarak Amerika'da Colorado eyaletinde gizlilik yasası içerisine eklenen bir hükümle nöral haklar da bu kapsama alındı. Ardından daha yakın bir tarihte Kaliforniya eyaletinde de benzer bir düzenleme kabul edildi. Sanıyorum henüz yürürlüğe girmedi ama metin kabul edildi ve bu kabul edilen metinle de aslında Kaliforniya Tüketici Gizliliği Yasası, genelde Türkiye'de de İngilizce karşılığı ile biliniyor. Californian Consumer Privacy Act, bir ek yapılarak nöral verilerde korunma altına alınacak hassas nitelikteki verilerin kapsamı içerisine alındı. Şimdi bu gelişmelere birkaç açıdan değerlendirmemiz gerektiğini düşünüyorum. Özellikle de Türkiye'deki hukuksal düzenlemelerle ilişkili olarak. Birincisi, nöral haklara ilişkin düzenlemelere ne oranda ihtiyacımız var ya da bu kapsamda neleri düşünebiliriz? İkincisi de zihinsel verilerin, kişisel verilerin korunması hukuku kapsamındaki yeri nedir soruları. Şimdi öncelikle nöro haklara baktığımızda burada özellikle önceki oturumlardaki açıklamaları düşünerek de söylüyorum. Belirli bir taraf alarak ya da buradaki haklar dizesini özel olarak savunarak yer vermedim. Ama özellikle bilişsel özgürlük, zihinsel gizlilik, zihinsel bütünlük, psikolojik devamlılık gibi hak alanlarına vurgu yapıldığını görüyoruz bu tartışmalarda. Ve bu sunumun odak konusu açısından baktığımızda özellikle zihinsel gizliliğin üzerinde durmak gerekiyor. Ve kabaca bunu bir kişinin zihinsel bilgilerini gizleme ve bilişsel alanına rıza dışı müdahaleleri önleme özgürlüğü ve kapasitesi olarak tanımlandığını görüyoruz. Bu tanım aslında doğrudan bireye kendi zihinsel verileri üzerinde bir karar verme yetkisi tanıyan bir tanım. Fakat kişisel verilerin korunmasına ilişkin pek çok tartışma alanında karşımıza çıktığı üzere bireyin kanaati her zaman için gerçek kanaati olmayabiliyor diyelim. Yani vermek istediğim örnek şu açıkçası. Buradaki zihinsel gizlilik tanımında aslında ilgili kişinin rızasına yapılan bir atıf var. Kişinin rızasıyla ilişkilendirme var. Oysa ki veri koruma alanında biz ilgili kişinin rızasının kimi zaman bir illüzyon yarattığını görüyoruz. consent illusion olarak da hani İngilizce ifadesiyle uzun zamandır literatürde tartışılan bir konu bu. Bizim günlük yaşamdaki aktivitelerimizi, etkinliklerimizi düşündüğümüzde de bu ifadenin neden kullanıldığını çok kolaylıkla anlayabiliriz esasında. Günlük hayatımız içerisinde hepimiz pek çok kez verilerimizin işlenmesine rıza gösteriyoruz. Özellikle de bilgisayarda ya da çeşitli işte internet sitelerinde ya da application'larda, uygulamalarda güncellemeler yaparken ya da bu uygulamaların yenilerini yüklerken bir takım kutucukları işaretliyoruz. Bazen e-postamıza gelen ikinci bir doğrulama adımı oluyor, onu da geçiyoruz. Ama çok azımız, hani belki de burada sorsam hiç kimse o metinlerin içeriğini okumuyor. Zaten bu konuda yapılan araştırmalar, incelemelerde bu rızaların esasında içeriği bilinmeden verildiğini net bir şekilde ortaya koyuyor. Çünkü çoğu zaman pop-up sayfalar şeklinde açılıyor ve o sayfadan geçişin çok hızlı olduğunu biliyoruz. Birkaç başka araştırmada aslında bu metinlerin tamamını okumaya kalkan kişilerin bir sene içerisinde ciddi bir zamanlarını, şu anda istatistiğin tam ayrıntısını unuttum ama böyle haftalar gibi bir zamanda sadece bunları okumaya ayırması gerektiğini söylüyor. Yani hayatın olağan akışıyla da uyumlu değil bütün bu metinleri okumamız. Bu nedenle kişisel verilerin korunması alanında rıza halen önemli bir unsur olmayı sürdürse de bunun yanında bu programları ya da verilerin işlediği herhangi bir yöntemi, uygulamayı geliştirenlerin belirli kurallara uymasını sağlayacak, prosedürlerini daha şeffaf kılacak ve hatta bunların geliştirilmesi aşamasında, örneğin tasarım aşamasında bu hakları gözetecek yaklaşımların güçlendiğini ve bunların daha ön plana çıktığını görüyoruz. Şimdi temel haklar açısından Türkiye'deki genel çerçeveye bakacak olursak, bu tartışma konusu açısından benim özellikle dikkat çekmek istediğim 3 anayasal hüküm var. Biri, anayasa açısından insan onuru düşüncesinin kaynağı olarak da görülen 17. maddenin 1. fıkrasında yer alan kişinin maddi ve manevi varlığını koruma ve geliştirme hakkı. Diğeri, kişisel verilerin korunması hakkını doğrudan bir anayasal hak haline getiren ve 2010 yılında anayasaya eklenen 20. maddenin 3. fıkrası, kişisel verilerin korunması hakkı. Üçüncüsü biraz daha belki ilginç görülebilir. Anayasanın 25. maddesinde düzenlenen düşünce ve kanaat hürriyeti. Üçüncüsü biraz daha ilginç görülebilir dememin nedeni şu. Aslında Türk Anayasası'ndaki, daha doğrusu 1982 Anayasası'ndaki bu hüküm oldukça tartışmalı bir hüküm olarak karşımıza geliyordu. 2001 anayasa değişikliklerine kadar. Çünkü 1982 Anayasası'nın 26. maddesinde düşünceyi açıklama özgürlüğü zaten düzenlenmiş durumda. 25. maddede düzenlenen ise doğrudan düşünce özgürlüğüne ilişkin. Ve 82 Anayasası'nın ilk şeklinde, yani bu hüküm açısından söylüyorum ya da bu bölüm açısından, temel hak ve özgürlükler rejimi açısından söylüyorum. 2001 öncesinde 13. madde ile temel hak ve özgürlüklere sınırlamalar getirilmişti. Önce sınırlamalar vardı, sonra haklar tanınıyordu. Neyse ki bu durum değişti. Ve o zaman tartışılan ve eleştirilen konulardan biri anayasanın kişilerin düşünce özgürlüğüne henüz bu özgürlüğü tanımadan bir sınırlama getirdiğiydi. Bu anayasa hukuk literatürü içerisinde tartışılan bir konuydu. Ve anayasada düşünce özgürlüğünün neden ayrı bir hüküm olarak düzenlendiği de tartışılıyordu bu tartışmalar kapsamında. Çünkü biz düşüncelerimizi dış dünyayla paylaştığımız zaman hukukun ancak konusu olabiliyordu. Sözümüzle, hareketimizle, kıyafetimizle ya da çeşitli dışarıya yansıyan tercihlerimizle. Düşünce ise insanın iç dünyasında yer alan ve dışarıya kendi hareketleriyle, davranışlarıyla yansıtmadığı sürece bilinmeyen ya da bilinmesi mümkün olmayan bir durum olarak değerlendiriliyordu. Şimdi nöroteknolojilerdeki gelişmeler aslında kişinin kendi isteğiyle ya da farkında bile olmadan iç dünyasındaki düşünce, duygu, hafıza, hayal gibi parçaların dış dünyaya yansıtılabileceği sorusunu getirdi. Bu bakış açısıyla değerlendirdiğimizde belki düşünce özgürlüğü önceki dönemde olduğundan daha anlamlı bir şekilde tartışılabilecek bir anayasal hüküm olarak karşımıza çıkabilir. Şimdi bu teknolojiler ya da bu alandaki, nöroteknoloji alanındaki gelişmeler neticesinde büyük oranda veri üretildiğini görüyoruz. Bu verilerin de çeşitli çalışmalarda, politika metinlerinde, akademik yayınlarda ya da biraz önce paylaştığım gibi hukuksal düzenlemelerde farklı şekillerde tanımlandığını görüyoruz. Ben özellikle dikkatimi çeken 4 tanıma yer vermek istedim. Biri en genel şekliyle nöro veri tanımı ve Avrupa Birliği'nin veri koruma gözetmeni European Data Protection Supervisor'ın yeni içinde bulunduğumuz yıl içerisinde yayınladığı bir metinde de bunun tanımlandığını görüyoruz. Buna göre nöro veri beyinden veya sinir sisteminden elde edilen bilgiler. Bunun dışında örneğin OECD'nin kişisel beyin verisi başlığıyla ayrı bir tanımlama yaptığını da ekleyebiliriz. Literatürde, akademide ise daha geniş, kapsamlı bu tanımların sınırlılığına işaret eden tanım önerilerinin geliştirildiğini görüyoruz. Bunlardan biri bilişsel biyometrik veri ve bu veri kategorisinin nöral verilerin yanı sıra belirli bir bireyden veya birey grubundan diğer biyometrik ve biyosensör verileri aracılığıyla toplanan, işlenebilen ve zihinsel durumları çıkarsamak için kullanılabilen diğer veriler olarak tanımlanmış. Yani bir başka ifadeyle bilişsel biyometrik veri ile ifade edilen sadece nöral veriler ile sınırlı değil. Bunun dışında dışarıya farklı davranışlarla yansıyan verileri de bu kapsama alıyor. Aynı şekilde Ienka ve Malghieri'nin yakın tarihli bir makalesinde yer alan zihinsel veri tanımında da bir kişinin bilişsel, duygusal ve kavramsal durumları da dahil olmak üzere zihinsel durumlarını ortaya çıkarmak için organize edilebilen ve işlenebilen herhangi bir veri tanımının yer aldığını görüyoruz. Bu tanımsal farklılıklara aslında akademik bir tartışma ya da sadece kavramsal bir tartışma açısından değinmiyorum. Bu kavramsal farklılıkların ya da tanımsal farklılıkların uygulama üzerinde de bazı etkileri olabileceğini düşünüyorum. Hangi tanımı tercih ettiğimizin. Çünkü aslında zihinsel veriler olarak nitelendirdiğimiz verilerin bir kısmı, biraz önceki örneğime gidecek olursam, hani EEG gibi araçlarla belki ortaya çıkartılabiliyor. Ama öte yandan biz zihinsel etkinliklerimizi bilinçli, yarı bilinçli ya da bilinçsiz olarak dışarıya yönelik hareketlerimizle de gösteriyoruz. Ve kişisel verilerin korunması alanı açısından özellikle bu son kategoriye ilişkin bugüne kadar yapılmış pek çok tartışma var. 2012 yılında söz konusu olan ve tartışılmış, 2014 yılında tartışılmış bir skandaldan bu bağlamda söz edebilirim. Oldukça da saygın bir dergide yayınlanan bir araştırmanın da, bir araştırma makalesinin de konusunu oluşturuyor aslında bu. Facebook üzerinden yaklaşık 700.000 kullanıcıya ulaşarak bir araştırma yapılıyor. Araştırmanın amacı şu: newsfeed denilen haber akışı içerisinde kişilerin karşılaştıkları paylaşımların onların duygu durumunu ne oranda etkilediğini anlamak. Örneğin siz sürekli olumsuz postlarla karşılaşıyorsanız, paylaşımlarla karşılaşıyorsanız, sizin paylaşımlarınızda da bir değişim oluyor mu? Ya da hep olumlularla karşılaşıyorsanız, güzel kutlamalar, olumlu haberler paylaşılıyorsa, bu sizin paylaşım pratiğinizi etkiliyor mu? Temel soru bu. Netice olarak da etkilediği sonucuna ulaşıyorlar bu araştırma neticesinde. Fakat burada iki temel problem var. Birincisi, yüz binlerce kullanıcı aslında farkında bile olmadan bir deneyin konusu haline getiriliyor bu araştırma açısından. Bunun etik bağlamda yarattığı bir tartışma var. İkinci olarak sonuçlar açısından baktığımızda da aslında karşılaşılan içeriğin bizim duygu durumumuzu etkileyebildiği ortaya konuluyor. Ve biz herhangi bir sosyal medya platformuyla, hatta herhangi bir internet sitesiyle etkileşime geçtiğimiz zaman hepimizin önüne aynı sonuçların gelmediğini biliyoruz. Sonuçların tercihini sağlayan algoritmaların geliştirilmesinde farklı farklı sahipler güdülüyor olabilir. Ama netice olarak benim gördüğümle bir başkasının yanında oturan, kendi telefonunu, bilgisayarını kullanan arkadaşımın karşılaştıkları aynı şeyler değil. Dolayısıyla karşılaştığımız içeriklerin bizim duygu durumumuz üzerinde manipülatif etkileri olabileceğini ortaya koyması açısından da bu araştırmanın çarpıcı olduğunu söyleyebiliriz. Veri koruması alanında kişilerin verilerinin işlenerek onların yaşamlarına ilişkin sonuçların ortaya çıkması elbette ki kişinin bilgisi dahilinde olması gereken bir konu olarak karşımızda. Bu nedenle de dediğim gibi bu boyutuyla zihinsel veriler aslında uzun zamandır kişisel verilerin korunmasının kapsamı içinde. Fakat gelişen nöroteknolojileri düşündüğümüz zaman bugün bu oturumdan önceki oturumlardaki paylaşımları ya da biraz önce paylaştığım EEG örneğini düşündüğümüz zaman kişisel verilerin korunmasına ilişkin düzenlemelerin bu araçlar aracılığıyla akan verileri korumaya ne kadar yarayacağını sormamız gerekiyor. Bunun için de öncelikle kişisel verilerin korunması hukukunun kapısından geçebiliyor muyuz ona bakmalıyız. Neden bu şekilde soruyorum soruyu? Çünkü herhangi bir uygulamanın ya da işte teknolojinin ya da herhangi bir usulün kişisel verilerin korunması hukukuna tabi olabilmesi için her şeyden önce bir kişisel verinin söz konusu olması gerekiyor. Peki nöral veriler ya da zihinsel veriler, farklı tanımları olduğundan söz ettim, kişisel veri midir? Bunun için kişisel verinin tanımına bakmamız gerekiyor. İki tanıma yer verdim. Biri Avrupa Birliği'nin kişisel verilerin korunması alanındaki çerçevesini belirleyen genel veri koruma tüzüğü, General Data Protection Regulation'daki tanım. Diğeri Türkiye'deki kişisel verilerin korunması kanunundaki tanım. Hemen şunu not düşeyim. Türkiye'de GDPR'a uyumlu bir veri koruma düzenlemesi yapılması yönünde bir istek var. Son yıllardaki politika metinlerine yansıyan resmi bir açıklama bu. Fakat öte taraftan mevcut düzenlemede aslında bir Avrupa Birliği bakış açısıyla geliştirilmiş bir düzenleme. Tam anlamıyla GDPR'a uyumlu değil ama bakış açısı benzer nitelikte. Ve Türkiye'de veri koruması alanındaki uygulamalarda da yorumlama gerektiren durumlarda her zaman ilk bakılan yer Avrupa Birliği uygulaması. Bu açıdan GDPR hükümleri ve onlara dayalı olarak verilen kararlar oluyor. Dolayısıyla GDPR'a ilişkin değerlendirmeler de Türkiye'de doğrudan hukuksal etki yaratabilecek nitelikte neredeyse. Doğrudan düzenleme olmasa da. Bizdeki tanım da, kişisel veri tanımı da GDPR'dakine oldukça benziyor. Orada ek açıklamalar var, bizde o ek açıklamalar yok. Ama kısa olana bakalım. Kişisel verinin tanımı ne? Kimliği belirli veya belirlenebilir, gerçek kişiye ilişkin her türlü bilgi. Peki zihinsel veri her zaman kişisel veri niteliğinde mi? Şimdi eğer ki herhangi bir araç ile elde edilen zihinsel veri doğrudan bir kişiyle ilişkilendirilmişse bu tartışmasız bir şekilde kişisel veri. Tanımda her türlü bilgi ifadesi yer alıyor. Dolayısıyla bunun bir işte EEG kaydı olması, bir görüntü olması, ses ya da yazı olması arasında herhangi bir fark yok. Peki doğrudan bir kişiyle ilişkilendirilmediyse o zaman kişisel veri niteliğinde mi? Tanıma baktığımızda belirli ya da belirlenebilir bir kişi kişiden söz ediyor. Tabii gerçek kişi olmak zorunda. GDPR'daki tanım da benzer nitelikte. Belirli bir kişi kolay aşabildiğimiz bir durum. Belirli bir kişiyle ilişkilendirilmiş. Belirlenebilir bir kişi ifadesinin neyi kapsadığı ise biraz daha tartışmalı. Nitekim Avrupa Birliği'nde de işte Novak, Breyer kararlarında gördüğümüz gibi kişisel verilerin bu anlamda anlamının ne olduğunun tartışıldığını biliyoruz. Burada iki farklı kriterden hareket edildiğini görüyoruz. Biri soyut teori, diğeri somut teori olarak ifade edilebilir. Soyut teori, eğer bir kişiye ilişkin, doğrudan kişiyle ilişkilendirilmemiş bir veri var ve fakat başka verilerle ilişkilendirilirse o kişiye ulaşılabilir. Bu başka verilere ilişkin bir sınırlandırma yok. Eğer o kişinin, o elimizdeki bilgi başka verilerle ilişkilendirildiğinde ilgili kişiye ulaşabiliyorsak o zaman bu kişisel veridir diyor. Bu teoriyi savunanlar ya da bu yaklaşımı benimseyenler. Somut teori ise veriyi işleyen kişinin elindeki bilgilerle, başka bilgilerle ilişkilendirildiği zaman kişi ortaya çıkıyor mu, çıkmıyor mu? Buna bakıyor. Yani aslına baktığınızda soyut teoriyi izleyenler çok daha geniş bir veri kategorisini kişisel veri olarak kabul ediyorlar. Somut teoriyi takip edenler daha dar. Ama her iki durumda da belirteçlerin kişisel veri olarak kabul edildiğini söylemek lazım. Bununla neyi ifade ediyorum? Mesela biraz önce belirttiğim Breyer kararında Avrupa Birliği Adalet Divanı bilgisayarların IP numaralarının kişisel veri olup olmadığını tartışıyor. Çünkü aslında IP numarası değişiyor, dinamik IP numaralarından söz ediyoruz. Ayrıca bilgisayarın başında her zaman aynı kişi oturmayabilir örneğin. Büyük oranda pek çok durum açısından bunun kişisel veri olduğuna karar veriyor. Çünkü çoğu zaman IP adresiyle yapılan kayıtlarda kişinin hareketleri ve diğer bilgilerle birleştirildiğinde ilgili kişinin, yani onu kullanan veri öznesinin kim olduğunun ortaya çıkabildiğini görüyoruz. Şimdi bu bağlamda baktığımızda zihinsel veriler açısından şu soruyu sormamız gerekiyor ya da şu saptamalarda bulunmamız ve sonunda da birazdan belirteceğim soruyu sormamız gerekiyor. Eğer ki doğrudan bir kişiyle ilişkiliyse kişisel veri ve bu düzenlemelere uygun hareket etmek gerekiyor. Eğer ki doğrudan bir kişiye ilişkin değil fakat başka bilgilerle birleştirildiğinde ulaşılabiliyorsa, örneğin elinizde A hastasının işte bir kaydı var, bu elde edilen verilere ilişkin. Hastanın adı gerçekten A olarak yazıyor. Yani bir takma adla yazıyor. Fakat hastanede o takma adın karşılığındaki hastanın kim olduğuna ilişkin de bir liste var. İki işleyen de aynı kurum. Dolayısıyla onlar ilişkilendirilebilir nitelikte olabilir ve belirlenebilir bir kişi diyebiliriz. Peki bu da yok. Benim elimde yalnızca işte önceki sunumları yapan konuşmacılardan biri burada böyle bir kaydını unuttu örneğin. Üzerinde hiçbir isim yazmıyor, hiçbir şey yazmıyor. Ama işte örneğin beyin dalgalarına ilişkin ya da beyninin elektriksel yapısına ilişkin bir takım verilerin olduğu bir dosya var. Bu tek başına kişisel veri olur mu? Bunu niye söylüyorum? Burada unutulması belki ciddi bir sıkıntı yaratmayacaktır. Teknik olarak bunu işleyebilecek bir kişi ya da konuşmayı yapan, bu kaydın sahibinin özel olarak çok önemli bir kişi olmadığını düşünecek olursak. Fakat bu tarz verilere dayalı olarak yapılan bilimsel araştırmalar var, akademik çalışmalar var. Ve o çalışmalar yapılırken bu hükümlere uygun mu hareket etmek gerekecek örneğin? Ya da doğrudan tüketiciye yönelik biraz önce paylaştığım örneklere benzer örnekler açısından ne olacak? Bu durumda sorunun yanıtını aslında doğrudan bu teknolojilerle ilgili çalışan kişilerin vermesi gerekiyor. Benim yaptığım araştırmalarda gördüğüm pek çok araştırmacının bizim parmak izimize benzer şekilde bir beyinsel ya da zihinsel izimizin de bulunduğu, dolayısıyla bu kayıtların en azından bazıları aracılığıyla ilgili kişiye ulaşmanın mümkün olduğunu söylüyor. Tabii ben uzmanlık alanım dolayısıyla bu bilgiyi denetleyebilecek durumda değilim. Ama eğer böyle bir durum varsa o zaman kişisel veri olarak nitelendirileceğini düşünebiliriz. İkinci bir soru, kişisel veri, zihinsel veriler. Bunu kabul ederek devam edelim. Peki özel nitelikli kişisel veri mi? Özel nitelikli kişisel veriler kimi zaman hassas veriler olarak da adlandırılıyor. Ayrımcılık gibi bazı zararlara neden olma olasılığı daha yüksek görüldüğü için daha güçlü bir korumaya tabi tutuluyor. Ve bu kategorideki verilerin sınırlı sayımla, hukuksal ifadesiyle numerus clausus olarak sayıldığını görüyoruz. Eğer ki bir zihinsel veri ya da nöral veri bu kategorilerden birinin içerisine giriyorsa hassas veri, dolayısıyla işlenmesi, hukuka uygun olarak işlenmesi daha zor. Bunlar içerisinde, buradaki kategorileri tek tek okumayayım ama kategoriler içerisinde özellikle sağlık verilerinin dikkat çektiğini görüyoruz. Hızlıca geçeceğim süre sınırı dolayısıyla. Sağlık verilerinin kişisel veri olma niteliği açısından herhangi bir tereddütümüz yok ve elbette ki zihinsel sağlığa ilişkin veriler de bu kapsamda. Fakat zihinsel veriler her zaman sağlıkla mı ilişkili? Her durumda öyle olmadığını görüyoruz. Özellikle duygulara ilişkin bir takım bilgiler sunuyorsa bunun sağlıkla ilişkisini kurmak her zaman kolay olmayabilir. Bu açıdan aslında kamusal yaklaşım açısından ya da bireysel değerlendirmeler açısından baktığımızda hassaslık niteliği açısından pek de şüphe duyulmayan zihinsel verilerin hukuksal karşılıkları anlamında aslında özel nitelikli veri olmayabileceğini görüyoruz. Buraları hızlıca geçiyorum çünkü sanıyorum zamanımın sonuna yaklaştım. Son olarak işaret etmek istediğim bir husus, diğer bütün alanlarda olduğu gibi bu teknoloji açısından da teknoloji belirli bir alanla sınırlı olarak gelişmiyor. Aslında pek çok farklı araştırma alanının, disiplinin ilişki içerisinde birbirini besleyerek ve destekleyerek büyüdüğünü görüyoruz. Ve pek çok farklı alanda olduğu gibi nöroteknolojiler açısından da yapay zeka kullanımının oldukça yaygın olduğunu saptayabiliyoruz. Yapay zeka devreye girdiğinde hukuksal düzenlemeler bağlamında yapay zekaya ilişkin durumları da dikkate almak gerekiyor. Ve bu konuda da özellikle son yılın en önemli konusu Avrupa Birliği'nde kabul edilen yapay zeka yasası oldu. Ve bu yasaya baktığımızda, yasa bu tabii ki hukuksal anlamda bir regülasyondur bu arada. Kendi kısaltmalarında yasa ifadesini kullandıkları için biz de tereddüt etmeden yasa diyebiliyoruz ama bir not olarak düşeyim. Risk temelli bir yaklaşımın benimsendiğini görüyoruz. Kabul edilemez risk, bu yasaklanan yapay zeka uygulamaları için söz konusu. Yüksek risk, sınırlı risk ve en az risk şeklinde farklı kategorilere ayrılabilecek bir yaklaşımın Avrupa Birliği yapay zeka yasasında benimsendiğini görüyoruz. Şimdi ben bu yasanın hali hazırda zaten çok tartışmalı olan düzenlemelerine girmeyeceğim. Ama iki hususa işaret edeceğim. Birincisi, yapay zekanın da kullanıldığı durumlarda veri işlemesi açısından her iki alana ilişkin düzenlemeleri bir arada değerlendirmek gerekiyor. İkincisi, yapay zeka yasasının getirdiği bu yeni yaklaşım, yani risk temelli yaklaşım, bana soracak olursanız kişisel verilerin korunması alanında da ciddi bir şekilde tartışmamız gereken bir yaklaşıma karşılık geliyor. Nitekim Daniel Salov gibi alanda öne çıkan bazı isimler de bu konuyu ufak ufak tartışmaya açmaya başladılar. Çünkü kişisel verilerin korunması alanında daha tırnak içerisinde riskli alanlar olarak görülen, örneğin hassas nitelikli veriler ayrı bir kategori olarak düzenleniyor. Ama her zaman bu kategori içerisinde yer alan veriler daha yüksek bir risk yaratmıyor ve hatta bazen de bu kategoride yer almayan ama çok hassas nitelikte olabilen verilerle karşılaşabiliyoruz. Bu hükümlerin uygulaması açısından, amacına uygun bir şekilde uygulanması açısından bazı soru işaretlerini beraberinde getiriyor. Son olarak veri korumasına ilişkin bir değerlendirme yapıldığı zaman özellikle de teknolojiyle ilişkili bir etkinlik içerisinde genelde veri koruması alanında konuşan kişinin söyledikleri çok uygun bir kelime bulmaya çalışıyorum. Sıcak karşılanmıyor. Çünkü çoğu zaman araştırmaların, etkinliklerin ya da gelişmenin önüne çekilen bir set olarak görülebiliyor. Oysa ki bu alanın temel amacı gelişmeleri engellemek değil, oluşabilecek yan etkileri ve hatta belki bazen hastanın ölümüne neden olabilecek orandaki büyük yan etkileri gidermek, zararın henüz zararın oluşmasını beklemeden bir takım önlemler alabilmeyi sağlamak. Bu açıdan nöroteknolojilere ilişkin değerlendirmelerde ve yaklaşımlarda da riskleri dikkate almanın önemli olduğunu düşünüyorum. Hem uygulamaların geliştirilmesi ve tartışılması açısından hem eğer gerekli ise yeni düzenlemelerin kabul edilmesi açısından. Bu nedenle de sunumumu tamamlarken Peter Brueghel'in 16. yüzyıldan günümüze kalan Ikarus'un düşüşü başlıklı tablosunu paylaşmak istedim. Sanatsal olarak çok güzel olması bir yana bilindiğini tahmin ettiğim işte Daidalos'un icatlar tanrısının Girit'teki labirentten oğluyla beraber kaçmak için icat ettiği kanatlarla fazla yükselen oğlu Ikarus'un düşüşünü anlatan bu tablo merkeze düşüşü değil, gündelik hayatı alması açısından da beni hep etkilemiştir. Çünkü Ikarus'un aslında sadece ayağını görüyoruz suya düşmüş olarak. Bu düşüşü yaşamamak için bu teknolojilerin ve özellikle verilerin nasıl kullanılacağına ilişkin soruları ivedilikle sormamız ve yanıtlamamız gerektiğini düşünüyorum. Beni dinlediğiniz için teşekkür ederim.
Teşekkür ederiz Elif Hocam. Ağzınıza sağlık. Zamanımız var mı sorular için, katkılar için? Evet. Any question and comments?
Çok teşekkürler, çok güzel bir sunumdu. Şimdi Avrupa Birliği uzun zamandır ambient assistant living ya da active assistant living dediğimiz bir alana yatırım yapıyor. Bu işte yaşlanan nüfusun evde kendi başlarına bakımı yapılabilsin diye daha akıllı ortamların yaratılması ile ilgili. Bu da tabii yapay zekanın evin içinde yaşayacak olan yaşlı bireyi takip etmesi ve gerektiğinde bu bilgileri doktora raporlamasını içeriyor. Fakat yapay zeka açısından şöyle bir şey var. İş yeri ve eğitim kurumlarında bu şekilde yapay zeka izlemesinin kullanılması yüksek risk olarak belirtiliyor. Şimdi iş yeri ama kimin iş yeri? Şimdi o kişinin kendi evi ama orada çalışan mesela hemşirenin iş yeri bir yandan. Dolayısıyla tanımlarda bir muğlaklık olduğu düşünülüyor. En azından bilgisayarcılarla hukukçuların bu konuda çok farklı görüşleri var. Şimdi bazı teknolojileri kişisel verileri ortadan kaldıracak şekilde düzenleyebiliyoruz. Mesela ben bir kameraya öyle bir işleme koyabilirim ki kişinin yüz görüntüsünü alır almaz alıp onun yerine bir iskelet koyar ve onun kimliksiz hale getirebilir. Ama bazı hukukçular diyor ki ya sen onu yapmak için o görüntüyü işleyeceksin bir kere. O noktada zaten kanunun sana dur demesi lazım. Sınırı nerede çizeceğiz? Bununla ilgili bir yani kanunlar bence muğlak ama siz daha iyi biliyorsunuz bunu.
Açık sandım, pardon.
Yani ikisi de muğlaklıkla ilgili aslında. Yani tanımlardaki bir muğlaklık sıkıntı yaratıyor asıl.
Şimdi muğlaklık bizim de sorunumuz. Hukuksal düzenlemeleri net bir şekilde anlamak istiyoruz. Hani uygulamasının nerede başladığını, nerede bittiğini bilmek istiyoruz. Pek çok düzenlemede bu her zaman olmuyor. Bazen kaçınılmaz olarak olmuyor. Kullanılan kavramların içeriğinin net olmaması dolayısıyla. Bazen mahkeme kararlarında beklediğimiz istikrarı görmüyoruz örneğin. Yorumlamada farklılaşma oluyor. Ama yani muğlaklık bu anlamda sizin kullandığınız anlamıyla muğlaklık hukukçuların da derdi olan bir konu. Onu söyleyebilirim. Ama muğlaklığı şu anlamda almadığımı da bunu ifade ederken belirtmek istiyorum. Hukukun mutlaka her bir konuya ilişkin kazuistik şekilde böyle tek her durumu düzenlemesi gerekmiyor. Ona hani muğlaklık demeyeceğimizi düşünerek onu dışarıda bırakıyorum. Veri koruması alanında aslında işte 50 yılı geçmiş bir tarih var ve bu zamandan Türkiye için söylemiyorum bu tabii. Avrupa'yı merkeze alarak söylüyorum. Çok yerleşmiş içtihatlar var. Pek çok kavramın içeriğinin olması gerektiği kadar doldurulduğunu görüyoruz. Yani çok muğlak bir alan değil ama teknoloji özellikle veri işleme teknolojileri ya da sistemleri, bilişim sistemleri yeni ürünler ortaya koydukça, yeni yöntemler ortaya koydukça yeni sorular geliyor ve tekrar bir yorumlama ihtiyacı oluyor. Bundan kaynaklı olarak bir belirsizliği hissettiğimizi söyleyebilirim. Türkiye özelinde baktığımızda o muğlaklık sorunu çok daha açık ve net bir şekilde söz konusu. Hatta şöyle söyleyeyim, Kişisel Verilerin Korunması Kanunu 33 maddelik bir kanun ve temel olarak da Avrupa Birliği'nde o dönemde yürürlükte olan bir direktif esas alınarak yapılmış bir düzenleme. Ama direktif kanunun muadili değil. Üye devletlere bu direktife bakın ve bunun içeriğine uygun bir düzenleme yapın diyen metinler aslında. Fakat biz sadece o çerçeveyi aldığımız için örneğin bir açık rızanın bile ne olduğunun ayrıca yorumlanması ihtiyacını hissediyoruz. Bu problemler bu açıdan bizim de kesinlikle uğraştığımız şeyler. Somut sorunuza gelecek olursam, yani o bir örnekti tabii ki anlıyorum. Özel olarak da hani benim daha önce üzerinde düşündüğüm bir örnek de değildi ev bakımı konusu. Ama siz bu örneği sunarken hemen düşündüğüm şey şu oldu. Orada o desteği sağlayan bilişim sisteminin kaydettiği veriler kime ilişkin veriler? Kaydettiği veriler sadece yaşlıya ilişkinse, çalışana ilişkin değilse örneğin. Çalışan açısından, yani yardım eden kişi açısından orası iş yeri ama yaşlı kişi açısından orası o kişinin evi. Dolayısıyla o hüküm içerisinde değerlendirilmeme olasılığı olabilir diye düşündüm. İkinci örneğiniz neydi? Onu hatırlatabilir misiniz? Sizde mi?
Kişinin yüzünün kapatılması.
Evet, anonimleştirmeye ilişkin çok teşekkürler. Bu noktada da eğer kişisel veri işleniyorsa, kişisel verinin işlenme anında bu düzenlemelere uygun hareket edilmesi bir zorunluluk. Siz daha sonradan o veriyi anonimleştirebilirsiniz ki kişisel verilerin korunması kanunu açısından baktığımızda bahsettiğim iki kriterden aslında geniş olanın kabul edildiğini buradan mefhumu muhalifle çıkartabiliriz. Çünkü anonimleştirilmenin tanımında hiçbir surette tekrar kişisel veri haline getirilmemesi öngörülmüş. Dolayısıyla herhangi bir ilişkilendirmeyle tekrar kişisel veri haline getirilemez diyor. Konunun teknik tarafında çalışanların çok eleştirdiği bir ifade bu açıkçası. Çünkü anonimleştirilen hemen hemen her veri zaten bir şeyle ilişkilendirilip geri döndürülebilir. Dolayısıyla anonimleştirilme tamamen devre dışı bırakılıyor gibi bir eleştiri var. Ama uygulamaya baktığımızda kurul kararlarına, bu konuya ilişkin genel yaklaşıma güçlü bir anonimleştirmenin yine de kabul edildiğini görüyoruz. Bu açıdan sizin bahsettiğiniz örnek için siz görseli aldınız, işlediniz. Bu süreçte mutlaka düzenlemelere uygun hareket etmeniz gerekiyor. Daha sonra onu anonimleştirdiniz ve tekrar geri dönemeyeceğini düşünüyoruz. O andan sonraki işlemelerinizde artık bu kanunun biraz önce kullandığım ifadesiyle kapısından girmenize gerek kalmıyor. Bilmiyorum, umarım açıklayıcı olmuştur.
Başka soru ve katkı var mı acaba?
Hocam öncelikle teşekkürler sunum için. Şu anda bu özellikle hukuki süreçle ilgili olan rüzgar, dalga diyelim. Güney Amerika'dan başladıktan sonra dediğiniz gibi Amerika'ya, oradan da İspanya üzerinden Avrupa'ya giriş yaptı. Ve şu anda coğrafi olarak da ilerliyor. Bu noktada da ancak hani görebildiğim kadarıyla özellikle zihinsel gezilik açıkçası herkesin ortaklaştığı bir yerde ve belki de hani olabilecek ya da hukuki düzenlemelere konu olabilecek en olası nöro haklardan birincisi demek de belki mümkün olabilir. Bu da kişisel verilerin son dönemdeki gelişmesinden kaynaklı belki de. Bunun üzerine tabii bir yandan da işte Birleşmiş Milletler Kasım 2025'te keza nöro verilerin kullanımı ile ilgili bir standartizasyonunu açıklayacağına dair bir beyanı var. Ve ancak geldiğimiz noktada GDPR ve KVKK bizim karşımıza daha çok ilgilendiğimiz bir yerde. Bir öncelikle hani ilk sorum hocam, bizim burada hani sizin sunabileceğiniz çözüm önerisi olarak, yani biz bu süreçle karşılaştığımızda ne gibi bir çözüm önerisiyle gittiğimizde nöral verileri de keza koruma altına alabiliriz? Ekstradan bir hukuki düzenlemeye mi ihtiyaç var? Yoksa bir yorumda, çünkü hukuk haklar enflasyonu üzerinden siz de bahsettiniz. Yeni bir şey öğretmektense var olanları nasıl yorumlayıp ilerleyebiliriz? Bir çözüm önerisi var mı söyleyebileceğiniz? İkincisi de bu Avrupa Birliği AI Act'te 5. maddede yasaklı hareketler sayılmakta. Orada özellikle kişilerin davranışsal süreçlerini bozabilecek olan herhangi bir sürecinde ya da böyle bir teknolojilerin de aslında yasaklanması gerektiğiyle ilgili, yanlış çevirmediysem ya da hatırlamıyorsam, süreç var. Orası da bir yandan bizi nöroteknolojik gelişmelerle ilgili bir kısıtlamaya tabi tutuyor. Yani her ne kadar biz evet kişisel verileri koruyalım diyoruz ama bir yandan da AI Act'in de yasakladığı ve aslında ilerleyemeyebileceğimiz bir yer de mevcut. Ki sizin sunmuş olduğunuz örneklerdekine benzer türevi gelişmeler aslında oradan bir yandan yasaklanıyor da. Oradaki o sıkışıklık nasıl çözülebilir? Çünkü bir yandan da halihazırda bilimsel araştırmaya dair de bir özgürlüğümüz var insan varlıkları olarak. Oradaki o dilemma ile ilgili bir yorumunuz var mı? Onu merak ediyorum. Teşekkür ederim.
Peki, ben teşekkür ederim. İlk soru açısından şimdi kişisel veri olup olmadığı noktada çok nöral haklarla ya da zihinsel verilerle ilişkili yeni bir tanımlama gerektirdiğini düşünmüyorum. Ama ondan bağımsız olarak kişisel veri tanımı üzerinde düşünmemiz gerektiğini düşünüyorum. Hani onu not düşmek isterim. Nedeni de şu: kişisel veri çok bireysel bir yaklaşımla hani kişi ve kişiye ilişkin bilgi ve bunun yaratabileceği sorunlara, bunun işlenmesini yaratabileceği sorunlara odaklanarak tanımlanmış. Fakat biz bazen grup verilerinin de, yani doğrudan bir kişiye ilişkin olmayan bir grup insana ilişkin olan verilerin işlenmesinin de tek tek insanlar üzerinde çok büyük etkiler yaratabildiğini görüyoruz. Mesela işte şu mahallede oturanlar işte şu siyasal görüşe sahiptir ya da bu mahallede oturanlar şu sosyal işte bakış açısına sahiptir gibi ve bu eğer karar alma süreçlerini etkiliyorsa daha sonrasında örneğin kamusal hizmetler bağlamında, burada da aslında veri korumasında amaçladığımız, veri koruması ile amaçladığımız bazı değerlerle örtüşen konularla ya da sorunlarla karşılaşıyoruz. Yani bu bence tartışmaya açık, düşünülebilecek bir konu. Ama nöral haklar ya da zihinsel veriler özelinde kişisel veri tanımının yenilenmesi açıkçası bana sanki çok gerekli gibi gelmiyor. Fakat hassas nitelikte olduğunu düşünebiliriz gerçekten bu verilerin. Ve eğer ki rejimi bu şekilde devam ettireceksek, yani genel nitelikli kişisel veriler ve özel nitelikli kişisel veriler ayrımı üzerinden sürdüreceksek, o zaman bir kategori olarak eklenmesi gerektiğini düşünürüm. Çünkü evet, kişinin sağlığına ilişkin konu kapsanabiliyor, biyometrikle ilişkilendirildiğini görüyoruz. Evet, o da dahil olabilir. Bazen belki genetik bir bilgiyle ilişkilendirilmiştir. Oradan o da dahil olabilir. Ama bunların hepsinin dışında kalan ama aynı hassaslığı taşıyan başka veri kategorileri de olacaktır. Ama daha iyi çözüm bence, benim çok uzun zamandır bu konu, yaklaşık 20 yıldır veri korumasına ilişkin çalışıyorum. En başından beri özel nitelikli veri ayrımının doğru olmadığını düşünen bir kişiyim ben. Yani somut olay bağlamında ya da risk temelli olarak bir değerlendirme bana daha doğru geliyor. Çünkü örneğin sizinle konuşurken gözlük taktığınızı görüyorum. Eğer moda için takmıyorsanız muhtemelen gözünüzde bir bozukluk olması gerekiyor gözlük takıyorsanız. Bu veri koruması anlamında bir sağlık verisi ve hassas nitelikli bir veri. Ama örneğin bir kişinin adres bilgisi hassas nitelikli bir veri değil ama Türkiye'de ne yazık ki her yıl yüzlerce kadın kaçmakta oldukları işte eşlerinin, eski sevgililerinin, yeni sevgililerinin adreslerini bulması dolayısıyla öldürülüyor. Bu somut olay bağlamında baktığımızda çok daha hassas nitelikte bir veri. Onun için bence riske dayalı olarak ya da somut olaya dayalı olarak değerlendirme yapmak daha ideal bir çözüm olur. O zaman da nöral verileri ayrıca koymak gerekmez. Ama bu yaklaşım şu anda genel kabul gören yaklaşım değil. Benim düşüncem bu. Onun için bu yönde bir değişiklik olacağını çok beklemediğim için nöral veri ekinin yapılması daha yerinde olur. İkinci soru anlamında yapay zeka ve yasaklanan o 5. maddede zannediyorum kastettiğiniz manipülatif amaçlarla kullanılmasıydı yapay zeka teknolojisinin. Bunun çok da kabul edilebilir bir yanı olduğunu düşünmüyorum. Çünkü nöroteknolojiler bağlamında baktığımızda olumlu bize katkı sağlayan yönlerinin hiçbiri birilerini manipüle etmeye, birilerinin farkında olmadan aslında bir yerlere yönlendirmeye yönelen şeyler değil ya da olmaması lazım. Onun için o yasağın buradaki gelişmeleri engelleyici bir yönünü ben göremiyorum açıkçası. Ama hani vardır bir örnek, hani bunu gerçek anlamda tartışabileceğimiz, onun üzerinden tabii ki konuşabiliriz. Ama şu anda benim aklıma gelen o şekilde bir örnek yok.
Çok teşekkür ediyoruz. Zaman da epeyce ilerledi. Sonraki konuşmaya geçelim isterseniz. Bağlantı noktasında bir sıkıntı var mı Ece Hanım? Hazır mı bir sonraki konuşmamız? O zaman geçebiliriz. Peki kendisini anons edelim. İkinci konuşmacımız İngiltere'den, Londra'dan online bağlanacak. Harry Lambert, Center for Neurotechnology and Law isimli bir merkezin kurucusu. Kendisi Neurotechnology, Product Liability and Personal Injury isimli konuşmasını yapacak. Mr. Lambert, can you hear us?
Hello, can everyone hear me okay?
Good afternoon, thank you very much. We are very excited to hear your talk. Please.
Thank you. I don't know if I can see these slides or if you can see them. I haven't got them visible to me, but they may be visible to you.
Could you please share your screen? Mr. Lambert, could you please share your screen?
Yes, 1 second.
We cannot see your screen, Mr. Lambert. Are you there? Can you hear me, Mr. Lambert?
Hi, sorry, I had understood that the slides would be visible to me and I could just click on them, but I'm trying to sort of download them for myself. But if you want, I can just continue and perhaps the slides can be circulated after the talk. I'm entirely in your hands. Ah, there we go.
Okay, we can start. We have your slides. Please.
Okay. Wonderful. Thank you very much indeed. So, right, so after, apologies for that. So my name is Harry Lambert. I'm a barrister here in London and also sit as a coroner investigating deaths. I think the reason I'm speaking today is because I'm also wear a third hat, which is the founder and head of the Centre for Neurotechnology and Law. And today I'm going to give a talk about how those interact with each other, so how my practice areas interact with neurotech, and with a particular focus on product liability. And what I say today mirrors a number of articles which I've published in the New Law Journal, all of which are available for free if anyone's interested in them. And in fact, thanks to Ozan, are being translated into Turkish, so they'll even be available in your mother tongue soon. But I was pretty pleased with the one on product liability, actually, just because it seems to have been a slightly neglected field of endeavour in this space, which is surprising in a way, because of course most, if not all, neurotechnology will be a product in inverted commas. So we're going to cover three things today. The first thing we're going to cover is just a very brief introduction to the Consumer Protection Act, which is the main piece of legislation in this area. And it's not, with a few caveats that we'll come to later, it's largely relevant both in the UK and in Europe. So it's not just relevant to my foggy little island, but it is Europe-wide. Then we'll look at some of the problems that neurotechnology presents to that framework. I'll try and cover them as well as we go, but that will be sort of focused on fleshing them out. And then very, very briefly at the end, we'll look at...
Excuse me, Mr. Lambert, could you please tell us which slide you are on? So sorry, we cannot follow your slides numbers.
Yeah, so if you, so I'm not sure if I can, so is it right that I can't control them then? I can't move them? Yeah, it doesn't seem to be. So we've gone past that. If perhaps let's, if you scoot through the next few, because so it moves forward, say 5.
If you can tell us which slide in each slide changes, we can change here.
Yeah. Okay. So then the next one, I'll say next slide to indicate when. There we go. So anyway, the first one is just a bit of a joke, really, because obviously there are pretty big time constraints because we've got about 7 minutes per topic. So it's going to be a sort of high-level review. But just as flag, it was a work commitment that meant I couldn't come in person this year, but I'd love to come next year, and perhaps at that stage I'll do something in more detail. But the joke is just how much can be achieved in 7 minutes or so per topic. So even in 5 minutes, we've got there, look, 485,639 people are going to have sex, no doubt regretting that they're not able to listen to this talk instead. And if you go to the next slide, I think even more incredibly, Donald Trump will lie on average 1.85 times in that time. So an awful lot can happen. And as a bit of an icebreaker, on the next slide, if you go to the next slide, there's some, and then the next one again. These are some remarkable achievements that have been done in well less than 7 minutes, and I'll leave that for your icebreaker or this evening's drinks to see, and a sort of bonus prize for anyone who can get all three. All right, well, with that in mind, next slide, please. With that frivolity out of the way. So a very brief introduction to the Consumer Protection Act. So it was introduced in the wake of the thalidomide tragedy. So in those cases, a mother had taken a pill and it had given birth as a result to children with birth defects and abnormalities. And the children brought claims, but those claims were fraught with difficulty under English law and I think most of European law, because they had to be brought in negligence. And so negligence is, as a concept, is allied to a reasonable level of care that a reasonable person would exercise in similar circumstances. So it's inherently sort of dovetailed to the industry standard, if you like. And the companies at that time said, and there was a germ of truth in it, although I think ultimately it was wrong, but they said, well, we didn't know that drugs could cross the placenta. So how were we meant to know that this would have happened? And there were a few other companies that were doing tests about drugs crossing the placenta, but they were, very much the sort of A-star companies and not the bog standard against which we should be tested and assessed. They were sort of the standard bearers for a future age, if you like. So you had this disaster of catastrophic proportions, which went completely uncompensated. And that was what the directive was geared towards, and that was what the directive tried to remedy. And so the directive in Europe is one of strict liability. So in other words, it depends on the condition of the product and not on the conduct of the person making the product. So if I buy a toaster, for example, and it explodes, under the old law, I would have had to show that the manufacturer did something wrong. So did they design something wrong? Was there something, did a particular worker make a mistake on the assembly line? Those are the questions that I have to answer. It was fiendishly difficult to do that. Obviously, years later, even finding out who was on duty that day, let alone whether they made a mistake, was nigh impossible. So now, because the focus is on the product and not the process or the conduct, it would be uncontroversial that the toaster is defective. Toasters are not meant to explode, and therefore I would have a claim for the exploding toaster. So that was the idea. I think it's probably fair to say that in the UK, at least, the regime has failed. I think again, that's perhaps something to explore more next year if I come and do something in more detail, but it's made things fiendishly complicated. It's possibly better in Europe, where there's more of a sort of purposive and less rigid interpretation. But now, as of about 2 months ago, there's also the 2024 European Directive, and so that has so the 1985 directive was obviously drafted in 1985, before the internet, before neurotechnology, before AI, and the 2024 update is trying to put that right and make it suitable for the digital age. But of course, because of Brexit, we don't have that update over here, so we're still stuck in the time of toasters and kettles, although there is talk of, or there's a bill in place to update this. So we've got a chance to get this right. But the bill doesn't go into any detail about what's going to be done. It's just effectively earmarking the parliamentary intention. So I'm going to look in a moment, if we go to the next slide, at the basic features of the Consumer Protection Act. And I'll just pause before I do that. Am I going at the right pace for the translator and also for people perhaps whose first language isn't English, or am I going too fast? I'll carry on at roughly this pace. But if I'm going too fast, either for the translator or as I say, those whose first language is Turkish, then please do put a comment in the box, and I'll be able to read that. So the basic features of the Consumer Protection Act. So we've got it applies to consumers and not businesses, as the name of the act suggests. It applies to personal injury and not property damage, but not other forms of damage. And that's something that perhaps we can come back to later in the context of neurotechnology, because it wouldn't cover, for example, your emotional autonomy, if you want to call it that. To take a silly example, if every time you were sad, a bit of neurofeedback sort of zapped you and it was able to make you a bit happier without telling you that it was doing that, that's not an injury. Doing that, it's also not property damage. So that kind of manipulation wouldn't be covered under the Act, even though that's perhaps one of the bigger concerns in this space. And then you'll see the definition of product, which, as I say, has been updated in Europe, but not in the UK. And then next slide, please. The defendants, again, this is clearly geared towards the manufacture of a kettle or something similar. So there's three types of defendant, and I've put some more detail on the slide so that people can read it at their leisure afterwards, but because I'm pushed for time, I won't go through all of it. But essentially, you can see that that's all geared towards the example of a kettle, a traditional product. Where in that paradigm would somebody producing neurotechnology fit? If, for example, there are software updates, so you are a manufacturer, but you only do the software updates, and perhaps the problem lies in the software update. Would that be covered? Not sure. Likewise, if you design the algorithm, again, something's gone wrong with the algorithm. The actual nuts and bolts of the tech is fine, but it's the algorithm that's gone wrong. Again, not entirely clear whether that's covered. And again, in Europe, it may be that they are better off now in light of the very recent change. But certainly in the UK law, it wouldn't be clear. So there are some issues there, even in terms of who you can bring the claim against in the first place. And then if we go to the next slide, please. So we see the definition of defect. So that's the fundamental concept at the heart of this. We have a definition by reference to the underlined bit in the second paragraph. If the safety of the product is not such as persons generally are entitled to expect. And so there's a fundamental question here, which is, well, what are people entitled to expect in the context of neurotechnology? And I have to say, I don't know what the answer to that is. I've got no idea, because certainly most people that I speak to don't even know what neurotechnology is, let alone have concrete expectations as to what it should provide. Now, the references there is to an entitled expectation, but clearly if the emphasis is just on what someone is entitled to expect rather than actually what they expect, it sort of takes us back to the industry standard, and it takes us back to the basis of that entitlement, and the general public bit is sort of airbrushed out of the test. It's also right to say that the developments in this field are moving so fast that by the time you have concrete expectations, they may well be outdated. And so that's the idea that Ray Kurzweil has publicized, the idea of the singularity, that technology will move at some point too quickly or quicker than humans' ability to adapt to it. And so again, it may be that this is something that is very well set up for toasters and kettles, but toasters and kettles do not advance year on year and become so complicated that we don't know how to work them. Next slide, please. And next slide again. So I've deliberately, as I say, I've deliberately left some in there so you can read it, but I won't touch on every aspect of defect. So the next point is limitation long stop. So there's a 10-year long stop in the directive and in the CPA. I mean, the first thing to say is that actually limitation, strictly speaking, is a slightly inaccurate shorthand, because limitation is a defence, so it's something that the defendant has to plead and say you're out of time. And if they don't take it, then the court won't look at it. Whereas long stop is actually a jurisdictional issue. So even if the defendant doesn't take the point, the court will still chuck the case out. So there's no need to plead it. And that runs from the time, next slide please, that the product is, quote, put into circulation, close quote. So if we have the next slide please. And put into circulation is a phrase of some considerable importance, but it's actually not mentioned anywhere in the English legislation. Again, we'll come back to that. But again, as we'll deal with in parts 2 and 3, what does that mean in the context of neurotechnology? What does it mean in the context of a machine learning? What does it mean in the context of software updates? Again, it's clear why this was written the way it was. When something leaves the factory and it's outside the sphere of control, if we go to the next slide, please. In fact, this is just to say, sorry, this is slightly out of order, but this is just to say that it is applied extremely strictly. So if we go to the next slide, please. So that the 10-year long stop, and this is, I think, unique in English law, perhaps one other example at most, but it overrides the provisions on disability. So in other words, even if you're unconscious and you don't know that you have a claim, the clock will still keep ticking. Next slide, please. And I think the next, yeah, there we go. And it overrides fraud, concealment, and mistakes. Again, quite extraordinary that you can have a defendant who is behaving fraudulently and keeps the facts of the claim from you. In pretty much every other context, the law says, well, obviously that's unconscionable behaviour, so we have to stop time running, and your limitation period doesn't start later. Not so here. So it actually, even if it's concealed from you, the 10 years starts to run. And so it's, to give a concrete example, if you take a pill and you're fine for 10 years, and then after 10 years and 1 day, you start to turn green with purple spots, well, that's tough luck, your long stop, even though you hadn't even suffered the injury until after the 10 years. So it really, really is strict. And as I say, it's difficult to think of any other provision in English law which works in that way. So, and next slide, please. And next slide again. And the next one again. This is the case of O'Byrne, which I won't touch on, perhaps can come back to next year. But there we go, next slide. So put into circulation in broad terms is defined by reference to losing control. So again, going back to what I was saying a moment ago, in relation to a toaster or a kettle, that's quite easy. You lose control when it sort of leaves the factory gate, as it were. But it's much more difficult, a much more nuanced question when you lose control in the context of neurotechnology. For example, if you've got a BCI implant, or they're meant to be for life. They're not put in with a view that in 10 years later you're going to have another one, because it's extremely invasive and risky surgery, and every time you touch the brain, you're risking damaging it. So you want to have something that lasts for life. There's a lot of thought being put in at the moment to chips that just dissolve into the brain, as opposed to just needing to be replaced. And again, it seems as though the sphere of control is far longer in the case of neurotechnology than it would be in the case of a toaster. that is the long stop. And then the last feature I just wanted to touch on the Consumer Protection Act, just as a kind of whistle-stop tour, is the development risks defence. And this is sometimes known as the state-of-the-art defence. And the idea here is that when the directive was being brought in, it was a package of quid pro quos, and there was lobbying from defendants and lobbying from consumers. And it was felt that it was unfair to fix strict liability upon defendants without giving them a few get-out clauses. And so one is limitation long stop, which we've covered, and another big one is this development risks defence. And this basically says that you can't fix liability in circumstances where the defendant or the manufacturer couldn't have foreseen, couldn't have discovered that the particular thing would have gone wrong. So if we go forward, slide please. And again, I'm going to scoot over this a little bit, but I've left the wording in there for those who are interested. So if we go to the next slide. And again, next slide, please. Yeah, so the burden of establishing that is on the defendant. And then next slide again, please. So the only thing of substance that I wanted to say on the DRD is that there are two schools of thought on this, and there's quite a lot of uncertainty in the case law. So what does it mean when you say it couldn't have been discovered? Well, one theory is that it means you couldn't have discovered it by reasonable means. And so, for example, the example given in the case law is if you are working on a product and unbeknownst to you, thousands of miles away in an obscure research laboratory in China, somebody has discovered that there's a risk to do with your product, and they publish that in an obscure Mandarin language journal, then, and you don't speak Mandarin and you're not aware of it, then you would pass the test on the reasonable means test, because you say, well, look, how on earth was I meant to know about that? There's nothing I could have done about it. But on a stricter interpretation of the test, which we'll now come to, you would fail the test because it was theoretically at least possible for you to have gleaned that information or discovered it. So there is a bit of a jurisprudential debate about which one applies. If we go to the next slide, please. So the next one, the other alternative, as I say, is absolute undiscoverability. And that asks, as I say, whether you could theoretically have discovered or whether it would have required some sort of quantum leap in human understanding. So if you sell me a beef burger and then, this is before the discovery of Creutzfeldt-Jakob disease, and then 5 years later I get Creutzfeldt-Jakob disease, that's the kind of impossibility that's envisaged. It's something that wasn't in anybody's contemplation when you started making burgers. Now there's a question mark, again, bringing this back to neurotechnologies specifically, there's a question mark as to whether it really works in this sphere. Again, great for a toaster, less great for something that gradually influences somebody over time. So in terms of the sorry, I'll come back to that. Long stuff. In terms of the therapeutic needs that some people have, there may be a product which is, and indeed Neuralink are operating in this space, where you say, well, look, we want this treatment, even though we know there are very large risks attached to it. And again, this is something I hear a lot actually from a lot of clinicians at the coalface, that they are in a bit of a regulatory dead end because they have something which they know is very, very risky. Patient knows it's very, very risky, but they would nevertheless want to take it because they've got nothing to lose, and they're not allowed to pursue it. And so there's a sort of inhibitory effect on science and progress. And you can imagine an example where you say to somebody with somebody with full body paralysis, or in a coma or something, there is a 75% chance that this will cure you, and you will be able to walk again. You'll be able to do all the things you couldn't. You'll be able to speak again. But there's a 25% chance that it will kill you. Well, again, you could imagine someone, probably most people in that situation would want to take it. But if it then goes on to the 25% risk to materialize and the patient does die, then the defendant couldn't rely upon this defense because it was known. Now, the answer might be, well, what you're really saying is that the product is not defective, but I'm not sure that is conceptually what's going on. It seems to be that conceptually, in reality, it is defective. An implant isn't meant to kill you, so it is defective in that sense. And you were prepared to take the relevant development risk. So again, it seems a bit unfair, that side, on the defendant's side, that it can't be relied upon. So again, query whether it works in this context. I'd also say that again, going back to the package of reforms, which were meant to strike a balance between the consumer and big business. In the 80s, if you compare companies, their reach and influence then with their reach and influence now, especially with the internet and social media, etc., the reach and influence of businesses has grown considerably. And so you could argue, and I think I probably would argue, that in terms of striking the balance, a different balance needs to be drawn in 2020-24 vis-a-vis the 1980s. And again, going back slightly to Longstop, in particular in something like that, because the argument was, well, a business should be able to just draw a line under something and move on and not worry about those liabilities. But again, it's a very different situation where somebody still has the product in their brain. You shouldn't be able to move on and draw a line under it there. So those are the main aspects of the Consumer Protection Act, and I see we're slightly running out of time, but I'll do the next bit as quickly as I can. So if we go to part two, again, that's just left in for people if they're interested in it, and I can expand on it later. But if we move on again to the next maybe 2 or 3 slides, and to part two of the talk, which is how well placed is neurotechnology. Here we go. So now we've touched on these as we go, but just to flesh out some of the bigger concerns. So as I say, I've considered these in a recent article, which is free, and I'm sure Ozan can point you in the right direction, or if not, I can circulate it. But again, long-term insidious risk. If a kettle or a toaster injures you, you're going to know about it. You're going to know about it when it happens. And so that is the paradigm that we're working within under the CPA. But the neurotechnology impact can be very different, not always, but can be very different. So it can be gradual, it can be insidious, and it can be not immediately apparent. And so one example would be micro injuries from invasive neurostimulation, and they don't present any symptomatic effects until it's too late, until there's a very serious injury. And the same of neurotransmitter imbalances. They don't lead to symptoms, and then suddenly they lead to a mood disorder. So it works and it operates in a different way. I think it's also important to recognize that the brain is very plastic. And so when you're putting something in the brain or something that interfaces with the brain, it may be that it has no deleterious effects at the beginning, but because the brain is plastic and molds itself with each interaction that it has, it could mold its way very slowly and over time. And that's a particular concern in the case of children. And so the UNICEF report, and again, this is relatively recent, I think, focused on that, and they've done a whole report on the dangers of neurotechnology for children. And there's some nice quotes in there, one of which is that and it's referring to the plasticity of the brain, and it calls that a critical vulnerability, noting that the risks stemming from the misuse of neurotechnology are particularly significant for children, because childhood is a critical time for brain development and identity formation. And I think that's a really important point, the identity formation bit as well, because it also presents quite a novel challenge of disentangling sort of innate characteristics from characteristics that have been encouraged by nudging or by other means of neurotechnology. And again, in particular in relation to a child, where perhaps they've had this implant since they were 10, it's going to be extremely difficult, if not impossible, to undertake that disentangling process. So, the idea here is that there's subtle alterations of neural pathways and cognitive processes which are going to be very, very difficult to discern. I think it's also, in that example, it would also be very difficult to prove causation under the Act. How would you prove, if a 10-year-old ends up becoming addicted to video games or whatever it is, how could you prove that that's actually to do with the neurotechnology as opposed to just innate character of the child? I don't say that as a weakness in the legislation, because I think that causative link needs to be there, but at the same time it's obviously an extremely difficult question to answer. And then note too that we've got this a recurring theme really of what we've looked at, which is the definition of a defect is a snapshot in time from when the product is released onto the market, when it leaves the factory gates. And here, how are we going to deal with that? There's all sorts of problems that arise in that context. Firstly, well, the problem may develop after it's left the market. It's the software update 3 years later that addicts you to video games or whatever. Or it's something that happens so slowly it happens after the 10-year-long stop. There's all sorts of issues in terms of long-term and insidious gain. And as I say, the policy consideration that defendants should be allowed to draw a line under something after it's 10 years old just doesn't apply, where it's still in our 10-year-old's brain. He's now 20. Well, so what? He's 20, he's got the rest of his life. So clearly there are different policy considerations there. The next problem, next slide please, is harm falling short of personal injury. So I touched on this earlier, that the Act only deals with personal injury and with property damage. And so anything else is not going to be covered. In the article I give some examples of the slow erosion of your mental privacy, or the subtle diminution of cognitive abilities, or a subtle manipulation of your behaviour. And in fact, even worse, I think probably the best example really is addiction. Because addiction, as things stand, is not a recognised psychiatric condition, or at least not in this context. It can be if you're addicted to a substance, and it can be if you're addicted to a video game. But if you're addicted to anything other than those things, it's not a psychiatrically recognised disorder. And then under English law, at least, it almost certainly wouldn't be an injury, and you wouldn't be able to claim for it. So any kind of addiction would not fall within the Act. At least until mainstream psychiatry catches up. And then there's also this fascinating question about changes in personality over time. So there's quite a few papers have looked into this and looked at how having a chip in the brain can actually progressively alter your personality, your identity, your sense of self, and all sorts of things which may not be obvious before you do it, but which happen. And then again, it's impossible to put the genie back in the bottle. So they have immediate implications for individual autonomy. And again, to take another sort of deliberately simplistic example, but just to make the point, if a BCI in my brain makes me choose Coca-Cola over Pepsi, then again, it's not going to be a personal injury. It's not going to be property damage. But it clearly something tortious and something unlawful has happened, but it's something that the CPA just isn't geared to deal with. And the answer to that might be that you could bring a claim under the Human Rights Act, and I would accept that it offers some form of redress, but I think certainly in how it's implemented in the UK, there are real problems with that. I mean, firstly, its effectiveness is massively reduced by the fact that you have to, it only operates against emanations of the state. So, for example, if it was Pepsi, that did some clever neuromarketing in your BCI and got you to drink Pepsi, then you couldn't bring a Human Rights Act claim against Pepsi because they're not an emanation of the state. And they're the most likely, frankly, to be doing these infringements. There's also a very short limitation period, 1 year for the Human Rights Act. And there's also very low general damages for Human Rights Act claims. It tends to be a couple of £1,000s. And so again, is that really adequate compensation? Is it really a deterrent to defendant companies with their billions and billions of pounds? Probably not. And so is it really an adequate remedy? Again, I would argue probably not. So that deals with the Human Rights Act. The other thing, just to say on before we go to machine learning, just on this second point, is that it's about what persons generally regard as that person generally is the barometer of safety under the Act. So if we have a brain-computer interface that influences my decisions and makes me choose Pepsi over Coke, in some sort of subtle way, clearly that is clearly it's not an injury, but clearly that's something that, looking at the rationale of the Act, is something that persons generally would regard as unsafe and would regard as unsatisfactory, even though the Consumer Protection Act lacks the kind of vocabulary, if you like, to actually express that and why that might be. And then lastly, machine learning. So we've got this fundamental question about whether something that is designed to make mistakes, designed to learn from its errors, whether that constitutes a defect, because ultimately it is an error, or whether it's operating exactly as it should, because it's designed to make mistakes and then improve and get better. And so you've got this sort of bizarre, iterative, self-correcting process which raises this fundamental question. And again, kettles and toasters are not iterative, they're not self-correcting, they're exactly the same 10 years later as they are when you buy them. So again, you have a sort of real question mark over how the CPA operates in that space. And sorry, just I think the printer, when I printed off my notes, didn't actually print off everything, so I've just got one last thing to say. Ah, yes. So I think the problem that gives rise to is that there's a sort of evolving standard of care. So you have a situation where perhaps when a product is released, it might be the best in class, it might be fantastic. But 5 years later, after it's released, by the time of the update, it's the worst in class, or it's a problem which every other company in the market has solved, but this one hasn't solved. And so, again, that suggests that it's there's an evolving standard of care. It was fine when it left the factory gates, but 5 years later, it's not doing the thing that every other competitor is doing. So that kind of evolving standard of care, I think, is really tricky for all areas of law, but certainly the Consumer Protection Act as well. And I think the other thing is that in the context of machine learning, again, we touched on this, but it's difficult to ascertain, what is really the expectations of the reasonable, or the entitled expectations of persons generally. And again, I go back to that idea of Ray Kurzweil and the singularity, and I go back to the idea that this is just moving so quickly that I don't think there are any concrete expectations. So in the article which I produced, which is there on the right-hand side, I've come up with some possible solutions. As I say in the article, I think that they're put forward with a certain sense of diffidence, but a diffidence that's appropriate to this being a somewhat novel point and a very tricky one. It's not for me to just say, oh, this is what we should do. But these are some ideas that I've had, and I genuinely would very much welcome some critical feedback and some thought and some discussion about it. So unfortunately, I can't do that in person with you this time, but in 2 years' time, I'm very much looking forward to do that in person. Thank you very much.
Thank you very much, Mr. Lambert. Unfortunately, we are a little out of our timetable. That's why we cannot have questions. Thank you very much.
Thank you.
Good afternoon again. Today's last speaker, Ozan Erözden. He will talk about how private could brain data be. He is from Kadir University Faculty of Law, Dean of the Faculty of Law.
Okay, thank you very much. I'm aware that you are all very tired, as well as me, so I will keep it as short as possible. I will start as a classical lawyer with a case study. I cannot. Oh yeah. So, the Supreme Court of Chile just delivered almost a year ago, more than a year ago, landmark ruling in a case that involved. Actually, the case was initiated by former Senator Giulio Girardi against the neurotech company Emotiv regarding the company's product called Insight. So this is the Insight. The person on the photo is not Senator Girardi. He's a bearded man, so this is another one. But this is the product, actually. Alan also showed another picture of this product. This is a 5-channel EEG headset designed for, this is a personal neurotechnology for personal use, designed for brain-computer interface. According to the information given by Emotiv, it can be used for different purposes like raw EEG, mental command, like flying drones and stuff like that. And what does this machine? It records the brain's electrical activity, stores data, and stores data, putting it in an iCloud space provided by the company. So Mr. Girardi claimed that Emotiv's procedures concerning data storage and processing were in breach of Chilean legislation concerning personal data protection, and also another constitutional clause which Elif Küzeci has talked about, concerning the protection of mental privacy, or the protection of brain activity from misuse of technologies, were also mentioned in the case. Actually, this is an interesting case of legal action. Usually, because Senator Girardi was the one who initiated this constitutional clause, and then after this case in front of the court, usually legal mobilization goes the other way around. First you initiate cases before courts, and then the legislation comes, but this was the vice versa action taken here. Anyway, the court said that state has a duty to protect human integrity in its totality, including privacy and confidentiality. And mental privacy is an important aspect of human dignity. That was the essence of the ruling, according to some accounts. And the promoters of neurorights were praising this case because they are claiming that brain data, neural data, should be considered as a distinct category, separate category from personal data. So this is not personal data, this is something else. So personal data is defined in the way that has been discussed here in length. So I'm not going to go again through this. But the argument behind the claim that neural data is not personal data is the following. So neurodata is not merely personal data because they provide information concerning an individual's mental activity, and the mental activity of an individual is it equals to the personality of that person. So so safeguarding human dignity directly relates to safeguarding mental privacy, because mental privacy is the protection of human personality, because the mental activity is the personality itself. So, and the neurorights movement, let's say, were seeking the enactment of such a clause, either in human rights documents or in some other legal documents. And the neurorights movement has been so far very successful in advocating some legal changes, both on international level and national level. So Chilean legislation is one of the examples, and there are some other examples which are being mentioned here. So let's analyze the theoretical construction of this line of thinking. So what do we have here in hand? We have first the self, then the brain activity, and the brain activity is owned by the self, and there is a ownership relationship between the self and the brain activity. And this brain activity, on the other hand, is almost equal to personal identity or to the self, because it gives the whole information about mental processes of the self. So it has to be protected, the mental processes of the self, because it is almost the same thing as protecting the self itself. So brain activity should be protected because it is the person per se, the brain activity. And I'm going to elaborate this point of view from a critical perspective, actually. First of all, this is in line with the person definition, the definition of the person from Lockean, John Locke's perspective. A thinking, an intelligent being that has reason and reflection and can consider itself as itself, the same thing and think in different times and places. Well, okay. So we have the person. The person is a thinking thing, and the what makes a person is the continuity in its psychological domain, let's say. Actually, there are three different views on personality from an ontological perspective. either the personal identity is ensured by a continuity of immaterial soul. This has been a dominant view for maybe million years, but now in front of the current scientific knowledge, this has been this perspective has been left aside. Then we have the idea of persons, whether they are material beings or so we have the idea that the persons that are material beings, but we are discussing whether this material being's continuity is ensured by a psychological continuity, which is in relation with Locke's definition of person that I have been talking about, or it should be understood as the continuity of an organism, the biological approach. So as long as the organism exists, then there is a continuity. We don't take into account the psychology may be an essential part of the biological organism, but this is not what defines the continuity in personality, in person. And so the psychological approach, and of course the immaterial continuity, soul's continuity approach, can be seen from this perspective of mental phenomena and ownership. So the mental phenomena is owned by the organism, or it is related to the organism in a specific way. So we have the idea that mental phenomena cannot exist without having a bearer. The experience needs, mental experience needs an experiencer. The thought needs a thinker, etc. So this is, well, there may be, of course, another perspective. For instance, you may just experience out-of-body experience by taking a substance which is not approved yet for depression treatment, or and listening to a Jefferson Airplane, or there's another way of thinking about. So in Alice's Adventures in Wonderland, Alice meets a cat which goes on and off, and sometimes leaving the green behind. So the green without a greener is something which is unthinkable and unimaginable, except this. But there is this understanding of mental phenomena as well, which can there should not be a bearer, there should not be an owner of the mental phenomena. That there may be the mental phenomena as a phenomenon, like lightning. So as there is no subject in lightning, the thought also should not be directed or linked to a thinker. For instance, Wittgenstein is one of the philosophers who is defending this idea of no bearer of mental phenomena. So his famous question is usually mentioned in frameworks related to philosophy of mind. What is left over if I subtract the fact that my arm goes up from the fact that I raise my arm. So if your answer is nothing, then there may not be a relationship of ownership between the mental phenomena and the way of constructing the biological organism. So from this perspective, that there can be another option which should be understood as the basis of trying to understand what is. So let's go back to the generic claim, the widely accepted claim. Mental privacy is part of psychological integrity. This is the idea of linking a person to the psychological continuity. And then this domain belongs to an individual, and then this individual should have total control over the mental activity, because this is the personality itself. So let's discuss this from another perspective. So brain data or mental activity, mental processes, what we are talking about, or what is the information concerning brain activity. So neural data is the data which is, well, where are my slides? So brain data is personal information, personal with a question mark, about neural states, processes and structures. I'm not going into the details here because many of you are very aware of these biological processes, I think. The thing that we call neural data or brain data is the activity chemical or electrical activity between neurons, which form the basic cell of the nervous system. We have some techniques to detect this activity, either by measuring the electrical activity or metabolic consequences of this physical or chemical activity. And the EEG is something which is based on measuring the electrical activity, and then so I'm going quick here, if I can, of course. Okay. With this data, we are acquiring a type of information. This type of information is called, in the philosophy of neuroscience, semantic information. Semantic information is the type of information which gives the idea about something else. So we have brain data. So let's think, for instance, if you are detected positive in a CPR test, then this data gives the information that you are carrying a certain type of virus. So there is such a relationship between the data and the information that is produced by the data. This is the semantic information. So brain activity, the records of the electrical activity of your brain gives you the idea who you are, or about what is the self, what is the person there. This is but only possible if you think about an ownership between brain activity or mental processes and the self itself. So I'm not going to elaborate this philosophical question, but again, from following this line, we end up with the idea that it is through the analysis of mental data, mental processing, it is even, I don't know why. It is even possible to read minds. So it is even possible to have a specific idea about the thoughts of a person who doesn't want these thoughts known by anyone or by some people around. But there is, as I said, again, possibility of taking a non-individualistic perspective. We can see brain activity as part of a biological organism's biological persistence strategies. So mental activity is not something different than any other biological process happening within an organism. And this biological processes, they are directly linked with the environment or with the others, with other impulses, and so there is a connectivity or a relationship between the organism and the surrounding environment, be it animated or non-animated. And we have, so usually the thing that we are seeing or observing in our animated world, usually organisms can be separated from each other from physical distances. There is this organism here which is separated than any other organism in this room. But nevertheless, this doesn't mean that this way of perceiving organisms separated from each other, so creating individualities between organisms, is something that tells us that gives us a direct idea, or which tells a specific truth concerning our existence. So I will just give you two examples, Abigail and Brittany Hansel. They are Siamese twins, so they cause a lot of problems for the legal system, whether they should have two social security numbers or just one. They are working as kindergarten instructors. So should they be paid in one salary, or should they get two salaries and everything? So there are tons of problems like that. And but then there may be, if you scan their brain, there may be another problem, whether the brain activity belong to two different persons or just one person. So another case which is more common than Siamese twins, the split brain syndrome. I'm not going to explain it in details again, but in this syndrome, the neural structure which connects two different hemispheres of the brain is not functioning or cut off, so that there is a difference of perception here. Then you see one body, but then two different perceptions. So again, from these, let's say, extreme situations or abnormal situations, we can go further and discuss the perception that the mental phenomena and the organism's ownership about this mental phenomena is something which should be debatable. So here, since our topic is neurotechnologies, I think it's time to discuss these extreme cases from a perspective which involves neurotechnologies as well. So I'm not talking about putting some neurotechnological, making some neurotechnological interventions in Siamese twins, but let's think about a future in which neurotechnology will be in our daily lives in a very widespread manner, and then the way of thinking about the normal, about what is normal and what is extreme or abnormal, has been changing totally compared to our current perspective. I think with this projection, we can think about a change in the way of thinking concerning, I don't know why these slides are just disappearing. Maybe it's Cheshire Cat slides. They are just coming in and out. But nevertheless, so I will finish here by saying that maybe we have to discuss neurotechnologies' impact from this perspective as well. And then instead of applying our concepts, which are maybe fit for our today's perception of reality, but they will have to change because our consideration about normal, what is normal and what is abnormal, will change with the neurotechnologies' impact in our daily lives. So thank you for listening.
Ozan Erözden'e teşekkür ederiz bu sunumu için. Biz de depresyon hastalarına bazen Alice eğer düşmeseydi harikalar dünyasını göremezdi deriz. Çok güzel bir sunumdu. Teşekkürler. Evet, soru ve katkılar. Buyurun.
Thank you very much for the talk. This was, I was inspired by Ozan Hoca's talk in the sense that I think most of the questions we are talking now are in relation to the emergent properties. So this dualist approach and reductionist approach, the relationship between the brain data and how cognitive processes and perceptual processes occur out of that. And obviously this link is poorly understood yet, so all of this multi-voxel pattern analysis that are being used in the MRI to decode brain activity and link it into what kind of sensory stimulus is linked, and they're really limited and only with very few stimuli and so. So I was just thinking, I think now that we are discussing whether brain data is really a personal data or not, is only possible because we don't know the link between how these emergent properties occur actually out of these biological processes. So if we knew all the parameters that's been involved in such relationship, I think the question would have been whether to acquire all of this data with respect to an individual that would be enough actually to resolve the emergent properties, the thoughts, the perceptions and memories. They are all basically kind of emergent properties of this neural information. The only reason why it's not as private now is because we don't know scientifically the link in between. And once it's known, I think it's going to be even, I mean, there won't be any need for this question anymore, that it would be the most private, I guess, information. Yes, just a question for the future then. Will there be any laws that would restrict, for example, the amount of information that could be collected and protected, let's say, in terms of data privacy and so? That would be enough, actually, to make this link between the emergent properties and the biological underpinnings.
Well, thank you very much for this inspiring question. But actually, I'm not a lawyer in the sense that thinking about legislation, how should we formulate laws, and so I don't have any specific answer for your question, unfortunately. But I think that as long as we keep with the current understanding of person in legal sense, then there will never be strong enough laws to protect the privacy in this sense, because there are many ways of capturing this data. It's not the brain scanning is not the only way to capture information about mental processes. So, in my opinion, legislative effort will never be enough in this respect to provide a real protection for privacy. I don't know whether this was a good, I mean, sufficient answer.
I'm very surprised by the decision of the Chilean case, because if I record a single neuron of anybody's brain and kind of, you know, broadcast this data even, unless I know to what sensory input this neuron is responding, I have no way of deciphering what it is about, right? And emotive, the data that has been sent to the cloud actually does not include the stimulus shown on the wearer of the emotive wearing person. So that's just some random numbers that are impossible to, it's even lower resolution than, let's say, a single pixel camera in relation to the identity or mental health. So I was thinking maybe, oh, this sounds like a PR scam by emotive, showing that, oh, we are actually so good that we can read mental states. And because otherwise, and also there's no harm, right? I mean, isn't this important in the legal sense? that you should be able to demonstrate some harm. Just the violation of privacy by itself does not mean anything unless you are harmed by that.
Well, actually, according to human rights law, if I start from the end, according to human rights law, there is a specific domain, the private domain of a person, which should not be violated under no circumstances. So if there is a violation into this privacy, there is no need of demonstrating any harm to claim of a violation of a right. So, for instance, someone reads your, I am old enough to have seen people writing letters with paper and pen, so I can give this example. If somebody reads another person's private letter, this is a breach of privacy. So there is no need for creating any further harm out of this breach. But yeah, when it comes to your first point, well, this may be, I think the PR situation worked for both sides, so there is no bad commercial. So this is a very, even I know now, and you all know, emotive and insight and everything. So, but I think the neuro rights movement also is trying to create a public opinion for the need of enacting some specific rights protecting brain activity against neurotechnologies, risks, and so on. So there may be a mutual interest in creating a PR effect in this case.
Any question and comment?
Yeah, maybe kind of follow on I suppose one way of thinking about it as well, and I wonder if what you think about this, Ozan, is that, you know, they asked them to delete the data so there'll be no future harms. You know, you could almost think of it as sort of preventing a future harm as well, couldn't you? If although the data might be hard to do much with now, it might be in the future, and Emotive had to delete it. So that was just a thought on that was kind of in relation to the question, a sort of follow-on point.
Yeah, actually, I'm not a specialist of data protection legislation procedures, but I think in this case, if this data is really a private data, then it should be either what was the legal term for that? Anonymized, or it should be deleted without any possibility to re-access to it. But this is something which I can just tell, not based on a specific in-depth knowledge on personal data protection, but just from my lawyer's common sense, let's say.
It was a long day. I think time to close. Thank you very much for your attention and comments. Teşekkürler.
We thank the panel for this session. Thus we conclude the first day of the conference. The second part of the conference will begin tomorrow at 10 a.m. in the same venue. We wish you all a good evening.